still have that text message in your phone today? Answer, yes. And did you look at that text message recently in the last day or two? Answer, yes. Question, now, prior to the last day or two, when was the last time you looked at that text message? Answer, the day I sent it, November 20th, 2018. Question, so you haven't looked at the message since? Answer, no. Question, when you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question, or excuse me, answer, it's an iMessage and it changed from delivered to read. Question, okay, so do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer, no, I didn't look at it for 7 years. Question, now the fact that it said read, did that stand out to you? Answer, yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Keith Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense, the first time the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked read and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the the state, which it never was, and because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response. And the defense's response, for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out,
I see what's going on, but I can't comment. Good morning, everybody. I do think there's I don't know what he's going to say. I think it's a discovery violation, even though she didn't use it.
One thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house, there's a footnote that the defense counsel talks about, which says, it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone once she saw it that he had the location, and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Caitlin Caneiro's phone that could corroborate or provide information that could be investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if it was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there. The iPad, I guess, based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Caneiro's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote, number 3 on page 4 of the defense's submission.
Boy, did he read
that,
it.
The defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial, that they were not sure if the state was going to call the either Susan, Katie, or Marissa, court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are on their witness list, the witness list is a list of people that may be called. It's not every, it's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial? So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to them being there and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast.
Huh?
I just want to say that I've disagreed with that from the door. I gave the March 20th date because everybody indicated that that's how long the trial would be. It was never what the court thought how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what was being said of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done, or how ultimately we come to the conclusion of where we are today. So defense also talks about state versus tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony. And there was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there. And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense in any case have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, it doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain. I'd submit to this court that over the course of the last 7 years, this office, myself, Ms. Wallace, paralegal team, my clerical staff, have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished, by a prior attorney from Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We've provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had. And I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court in tier intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language.
I think this is a weaker argument.
To participate in cooperative discovery, etc.
I'd like the argument that it's embodied in writing under tier because it was on the laptop or the iPad.
It's pretty clear what we have here. It's a clear situation. The court's insight is spot on. with respect to the Susan and Katie and Marissa, you know, a lot of what Ms. Mastalone said is accurate. We did make attempts, and just because we didn't, you know, Detective Petrozello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Caneiro would be released. Then, prior to trial, we made efforts again. I did speak to Ms. Mastalone about it. She said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So they were on our witness list, yes, but as the court noted, properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously. And then obviously it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Corey Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to belabor this anymore. It's clear exactly what we have here. It was a document, it was not provided, and there's other information.
Let me ask you this question. If
He's going to talk about a
the
continuance.
court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning five and a half weeks into a trial.
There's a testimony yesterday that she looked at, all of a sudden she looked at a text message and said read without the document. I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Yeah, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Because I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Wallace would disagree with me, that time is going to do anything at this point in time. It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Mastalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
So, but my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone. Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes. Is it electronically stored as far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before. So you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time. And in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying.
It's a continuing discovery obligation.
That this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it, but I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So yeah, you did have time. You absolutely had time to turn it over. And it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. Tier says one thing, it does. But Tier does not mention, and it does not deal with the fact when something, it's not created by you. No one's asking you to create anything in this case. It already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This, in this court's opinion, aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it and you didn't turn it over. So if your answer is anything other than when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, I frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not
oral
the
information
to elicit the testimony. And that's all.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance. So the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these
quite a dressing down
locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information is electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using.
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation.
Oh boy.
So if the
She
court
should just
finds
shut up.
otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions.
He asks first and then goes.
This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There was a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking.
I knew if she was going to tell him to stop. He doesn't realize he's the judge.
The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020, a contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
Didn't happen.
Judge, could I just,
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was.
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no.
You know what I'm asking you. It's not. We're not talking about AIG. We're talking about the fact. What's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
I don't. I mean,
You should sit down and let her take it.
I don't have a recollection of exactly where that came in the trial.
Okay.
I know I didn't. I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I'm not. I can't say.
Does anybody remember hearing something like that?
I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case. But number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission, because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists, and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these
And she's done that before.
without some testimony.
Mentioned testimony, and he called her on it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony. And I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible, piece of information, I don't know. It was in the discovery, and they don't have the iPad. So, from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutors, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds at school. So that's just to close the record in that regard.
I'll be back.
What this is an example of, if people need an explanation of what happened, I'd be happy to do it. But what this is an explanation of is the danger when you've got a rule. Oh boy, even banged the door. When you've got a rule and you skate really, really close to the line and you know better, but you think you're right on the line, but you think you're still safe. It is very, very risky behavior. And here, she wasn't just skating close to the line and staying on the safe line. She went over it. Discovery is not simply the documents that you decide you're going to use, and the ones you decide you don't use, you don't have to give the other side, because those documents may still be helpful to the other side. And even were that true, as the judge said, she didn't use the document, but she did use the information. And that really is over the line with regard to discovery. So she got a dressing out in court that I haven't heard a judge ever give. She kept fighting. She kept trying to make arguments. She tried to override him when he said he was talking. She's done that throughout. She doesn't know where the protocol is between the judge on the bench and the lawyer arguing to the judge. You have a right to be aggressive on the defense side. You have a right to continue to press an argument if you think you're correct, but you also have to do it in a manner that reflects the position of the judge vis-a-vis you. And she doesn't do it. She hasn't done it from the voir dire when I saw her do things equivalent to it. And now she's in big trouble. I don't know whether he'll file a bar complaint against her, which the judge may be able to do, saying she intentionally violated discovery rules. Certainly her standing with regard to the prosecution after this, you only have, one of the big things you have is your reputation for fairness and for ethics. And if you lose that, then you're not going to get a break from the judge. You won't get a break from the state, and practice is going to be harder. And she knows it. She knows it. And I've been seeing questions about mistrial. Well, they'll go forward. The issue will be if the judge decides not to let any of this in, and it sounds as though he may allow some of it in, but if this is going to be an appealable issue from the defense side, saying the defendant's Sixth Amendment rights were affected because this was relevant evidence. Hearing it for the first time, I don't think it is, because the information with regard to the iPad, Corey went in with his wife and took the stuff after the law enforcement had been through doing their work and investigation at the scene. It was after the fire, after the murder, so it has nothing to do with, it can't implicate him as to the murder or the arson. But what they want to use it for is he's the kind of person who does this sort of thing, and therefore it shows that he needs money. It shows that his character is bad, and therefore he's the one who might have done the murder and the arson. That's what she's trying to use it for, not that the investigation wasn't done well enough, and that's what the judge alluded to. I also had a question whether this shows ineffective assistance of counsel. That's a not as easy a question as the other one that I addressed. I don't think it does, because the evidence, the information we're talking about does not directly go to, is there enough evidence to convict Paul beyond a reasonable doubt? It's evidence that the judge said was inadmissible. So this issue is coming up because she's trying to come in around that ruling and get in what he told her she couldn't get in. So if he's making a ruling that it's inadmissible, then what she's trying to do here is to admit something that shouldn't be in evidence anyway, and that can't be an effective assistance of counsel, in my opinion. Yeah, allegedly Heidi said she's not the one in trouble, but her shoulders are tense. Yeah, this makes me feel really bad because lawyers should not operate this way. They just shouldn't. And defense lawyers get a bigger berth than the state does because of the Sixth Amendment right of the defendant, because whatever the lawyer does, you cannot affect the defendant's right to a fair trial. And so they get a larger berth, and this does not, is not the best example of ethical lawyering, in my opinion. Now, the judge may write an opinion about this, and that will, in terms of her reputation, injure her even more because the opinion will be out there. I can remember a time at the law college when we were looking at someone for a hire, and we did some research and found a court opinion, and I won't go into any of the details, and decided not to pursue this person at all. So this can have, if he writes this in an opinion, I mean, this is going to be reported in the news in that area. But if it gets in an opinion, something that's really, a more formal document, it's more harm to her. And as I say, an intentional violation of discovery, I don't think rises to the level of, a lawyer ethical violation, but it could, depending. She keeps talking about context. It could, depending on the context. So we will see. So Miami Dottie says, now Corey's in the jurors' minds, would you call him? This, to me, is even more reason not to, because they may be able to go into with him, depending on what the state asks, the fact that he and his wife were taking things out of the house. I mean, that's not obviously taking things out of the house like they're suggesting, I think, the jewelry, the Tiffany boxes, but the, the iPad, which has some value, is the kind of thing you would expect a brother and an uncle to be doing. It does seem pretty, bad. Trying to think of other words to describe it. Not showing high character. I mean, even if there are things in the house that are of value, if you were the brother and there's another brother, you might want to discuss what we should, or two nieces, what should we do? There are all these things, they have some value. Let's talk about how we divide them up. It still sounds grubby to be doing it so soon after the murders and the arson. And I didn't recall when Paul was arrested, but people in the chat said he was arrested on the arson pretty quickly after the murders and the fire. So Corey would not be talking to Paul about how to divide up those things of value, but he certainly could be talking to his nieces and his sister-in-law about it. So it is grubby. I was trying to think of a good word, and grubby is the word, at least. RV Reddy wants to know how Corey was able to access the crime scene. As I understand it, the scene was released. The investigators had done their investigation. The scene was released back, that he didn't skulk into the place, but I'm not sure of that. If someone in the chat has heard it differently, put it in the chat. I just think he went in after it was released, the way in the case with Savannah's mother, they released the scene and there were reporters up to the door, looking at it. And then they put the tape back out and they went back in and looked again. So I think it was after the scene was released, and the defense claim is that the fact that the iPad was taken, and who knows what's on the iPad, shows that the law enforcement didn't do a good enough job. They should have seized the iPad and looked at what was on the iPad. That is what I think the connection is that the defense is making. And that's the one that I think what happened. We don't know. I haven't seen the opinion. I wonder if the opinion is published, where the judge had said he was keeping out a lot of the third party or some of the third party evidence. And I'm guessing, without knowing, that the part that the defense could use to show the investigation wasn't adequate maybe is what can come in and not the other. But I'm not sure, because it looks as though what they want to use it for is character. This is why not having the documents, if they're sealed, or not reading them because they're hard to get at, puts us at a real disadvantage. Always much better to read the information. And the judge was very angry, and she doesn't know when to give up. She made the case, he said what he said. She could have said, respectfully, I disagree, and stop. This is the same way she questioned witnesses. They're not saying what she thinks they should say, so she gets into a tug-of-war fight with them. Bad enough when you do it with a witness. Very, very ill-advised if you do it with a judge. All right. So we're going to put questions on the screen, but I don't see the question. Amber, on my screen, I see the person who's asking the question, but not the question itself. I don't know whether it's my laptop that's in the wrong place, but I can't see the question. So the only way I can do it is go to a small screen. Let me do that. Okay. Question, wouldn't Corey get the device as he's the next of kin? Maybe, but their nieces. I don't know what Keith's will said. If he and his family were all gone, who would get what? And why go in? Why, it's still, who is asking the question? Melanie Greenberg. It is still skulking around to go in and not let the family know that you've taken things. I just think it's grubby. Even if the laptop or the iPad and other things were going to come to him ultimately, and I'm not sure that's true. Maybe it's true because he's a brother, and it's the nieces on the other side. I don't know the answer to that. That would take. You need context, facts. But in any event, he could have told them he was doing it and sat down with them and decided what to do. It's not brotherly or unclely for me to use a word that's terrible. It's not a word. I just made it up. Have I ever heard a judge yell like this? Usually judges keep their emotions under check. They don't usually yell. I have not heard someone in court get the kind of dressing down he did with her. But I also have not seen a lawyer, when something like this comes up, continue to push a position that the judge says he finds completely without merit. Could Corey sue the defense team for defamation of character and prove damage to his reputation and income? Probably not. In the first place, they haven't said he's a bad person because he did this. They're using evidence that they found. He can't deny that he took the iPad. I'm assuming he can't deny it, so it's factual. And in addition, they're presenting it in a judicial context, which gives them more insulation. And in any event, what damage to his reputation and income if it's true that he went into the house and took the iPad? I mean, truth is a defense in a defamation case. What's the argument for what's relevant about the fact that Corey may have taken the iPad or after the murders? Her claim is it's relevant because they're saying the law enforcement did not do an adequate investigation, that they locked onto Paul early. They didn't consider other possible suspects, i.e. Corey, and they didn't look at fully examine evidence at the scene that might have gone to exculpate Paul. We don't know because they didn't look. That's their claim. And their claim is reasonable doubt. I mean, the defense is reasonable doubt. Had you looked at the iPad, you might have found something that would have said it wasn't Paul, but you didn't look. Had you swabbed more places, you might have found Corey's DNA or somebody else's DNA, but you didn't do it. Had you sent Corey's DNA as a sample or a reference, when you sent the DNA of all the other family members, you might have discovered that Corey's DNA was on the jeans or was on the knife. That's the claim that they're making. That's the third-party guilt claim, and that's why they say it's relevant. Ollie says, maybe someone told Jory to get valuables out of the house. Well, if that's true, why did he keep it secret? He could have told his nieces. And who would have told him to get the valuables out? Law enforcement? They say they know nothing about it. Oh, no. Who is this? Lots of opinions? Lots of opinions, I think is what that is. Anyway, do I know if the defense has any more witnesses? No, I don't. Why wasn't the scene released to Keith's parents? The scene is released, and then whoever has the right to take control has the right to take control. It's released to whoever has the authority over the house. So in the case of Savannah and her mother, Nancy, once that scene is released, the family could have gone in and said, we're locking it up and we don't want anybody on the premises. They would have had the authority to do it. Thank you, Jersey Shore Living. I appreciate it a lot. So the judge also mentioned that he gave them 2 breaks yesterday and lunch. He went through all the time that they had. And to say, I probably heard me give a hoot when he said the trial was going faster than they expected, when I think the trial's been going as a snail's pace. But clearly the judge has a different view of the pace of a trial. And it surprises me because he doesn't appear to me to be the kind of litigator who would have gone at this pace or liked it if he was doing a trial, litigating. So Juliet Barn is saying Paul was locked up and Corey is next of kin. The fact that Paul was locked up doesn't eliminate him as next of kin. Mel von Monkers, thank you. Welcome. Love to have you. He's still next of kin. And the question is, does Corey have the authority to go in and do things without his brother or his brother's knowledge or permission just because his brother is in jail? I think the answer to that is no. But, that's not criminal law. That takes us into other areas of law. I lost that question about February. Well, she's saying that the niece in February 2019, did that, whatever it's called, that I never knew existed, where you can get into the iPad or other device of someone else if you're all in the same, whatever it is that it's called. Amber will put it up. And that's when she discovered that the iPad, you can do a locator. That's when she discovered the location of the iPad was at her uncle's. Okay. But this certainly is a different trial day from all the days when we heard about the experts, isn't it? Okay, Amber's telling us it's a Life 360 app, and I'm sure most of you in the chat know what that is. She explained it to me earlier, so I think intellectually know what it is, but I can't describe it orally. And by the way, since we have time, I'm going to do a grammatical lesson. So turn the sound down if you don't want to hear me get pedantic here, but it just annoyed me. Oral and verbal are not the same thing. Verbal means words. Verbal can be either written words or oral words. Oral means only oral. End of grammar lesson. Well, I must say, I resented getting up this morning earlier than even we'd been doing before, but this was worth it. I must say this was worth it. Amber's asking, can I not see the questions? I can see them when I go small screen, Amber. On the big screen, they're below where my screen ends. So I'm sure they're there. I can't see them. I can see the blue, like here, the RV Ready 369 on the big screen. I can see that, but then I can't see the question underneath. Ready 369, thank you for being a subscriber. I really appreciate it. Did Paul leave his phone at his home at the time of the murders? Now I'm trying to remember the evidence. I think the answer to that is yes, but everyone in the chat, you were watching also. I think the answer to that is yes for two reasons. I think I heard it, but also if you're going to be going to your brother's house to commit arson and murders, you don't want the phone with you that then can track and provide information that that's what you did. So I think it had to be left at home. But someone in the chat can certainly correct me if I'm wrong. I don't mind being corrected if I'm wrong. I'd rather be corrected if I'm wrong than for a wrong answer to live out there. That I think it would be terrible. Oh, Amber's giving me more information. She's probably right. Let's see what happens. Nope, it isn't, Amber. I put my mouse up and I still don't see it. Oh, now I see it. You're right. See, she's a marvel. Everybody in this chat is a marvel, given what I know about this stuff. I was saying, let me answer this question and then I'll say something. I answered that already. I was saying that during COVID at the university, all the other colleges, arts and sciences, teachers college, business college, people had to learn how to use PowerPoint on their own and share screen and do all kinds of things. And when we were doing hybrid teaching, which I've never met an instructor or a professor who liked hybrid at all. That meant you had people in the classroom, but they were also online, and you were dealing with both, and everybody hated that, including the students for that matter. But so everybody had to learn to do it, except the law school, because, people will tell you law professors are prima donnas on campus because our position was we were there to teach, not to learn technology. So each of us had an assistant in our classroom for the hybrid classes who handled the students who were coming in via Zoom online, handled bringing questions up, handled telling us that there was a question, all kinds of things. And I loved it at the time because I did want to focus on teaching, but it also meant, and that's only one example of it, that the kinds of tech stuff that everybody else learned, I never did because I never had to do it. We always had assistants to do all the tech stuff. If I had a question like the one that Amber answered, the IT people would come up and show me or do it for me. And it was lovely at the time. But now that I don't have a whole, support system of librarians and IT people and staff otherwise, and I have to do it on my own, it would have been nice to have learned some of it earlier. So there's my story. So these people are coming in late. They don't realize that the legal arguments may be much more interesting than anything someone is going to say on the stand. And for me, they typically are always more interesting. So now I'm in a situation where I can read them on the screen and there are no more questions. Isn't that life? Irony. When I was getting questions, I couldn't read them on the big screen. Now that I'm set up to read them on the big screen, the questions have ended. Well, I assume all of us in the chat, we may not have agreed on anything in this trial. We might have been 96% or 99% agreed, but never all of us were agreeing on something. But I am confident. I'm confident that on this matter, which I'm about to say, we're 100% in agreement, and that is, none of us would want to be sitting in open court or standing in open court and have a judge talk to us or raise his voice to us in the way that Monica was the beneficiary of today. I am sure we're 100% agreed on that. It's something that no one of us would want to. Now, look at her strut in. She's still pretending everything is okay. The prosecutors are not going to look at her. Even her co-counsel is having a little difficulty. People said, should they have been able to tag team? He got up to try to help, in part because he's representing the defendant also. I don't think he got up happily, but he did get up to try to help. And then he didn't get yelled at, but he also, look at them. They're not even talking to each other. She brought something for him to see. No eye contact. I think she still thinks she's right. We've had a lot of defendants who think that they're not guilty. And she seems to be someone who still thinks she's right. So Linda 460 says she thinks Monica's thick-skinned. She may well be, but I think what the judge did penetrated her thick skin. She may think he's wrong, but she's standing in open court in front of a fairly full gallery with another defense lawyer to her right and prosecutors behind her. So she's got lawyers hearing this. I don't care how thick your skin is. I don't think this was pleasurable or something you can just, forget or put aside. I don't think she can compartmentalize that well. I don't think anybody could compartmentalize that well, except, is that the definition of what is it, sociopath or psychopath, that you can compartmentalize? Not the definition, but part of the definition. Well, now we have people saying she's delusional and stupid. I don't think she's stupid. I still think that the case they were putting on was a good case given their evidence. And she was able to pivot well when she was forced to do it. She just didn't think she should have to do it. And delusional, I don't know. I think she knows what's going on. If by delusional you mean that she won't accept what the judge is saying and think she's right when most of us disagree, That I would agree is happening. I don't know whether I'd call it delusional or not. Maybe I just don't know the definition of delusional well enough. Okay. I'm asked by somebody, and I have to find it now. Murder asked it earlier, and I put it or suggested it, and I put it in the chat. Can you replay the dressing down later? Yeah, this is my video. You can find all of them for every day of the trial. This one will be up also, so you can go through it and find it and play it. And I'm going to do a good part of it in the recap tonight. Oh, that's because item 4173 missed it. Well, you really did miss something, I have to say. These events don't happen every day in a courtroom. So did Jennifer's family, because they came in to hear the testimony. They didn't think they needed to hear the argument. This is a good lesson for all of you. Sometimes legal arguments, they can be dry, and I know a lot of people think they're dry. Even many lawyers think they're dry. I happen to like almost all of them, but I'm in a minority. Certainly in a minority with regard to the entire community of watchers, and maybe in a minority even among lawyers. But I like to hear legal arguments. But there are some legal arguments that are more interesting than something that will go on at a trial, even if most days in trial are more interesting than legal arguments. Okay, now where is he going, Mr. Decker? Is he going to her? Now let's see if he even looks at her. Nope. He said something, but his eyes were down. No eye contact over there. And the judge will come out much more measured now. But he probably was not a happy lot, probably. He wasn't a happy camper yesterday, was not a happy camper when he got those briefs last night. At 10 o'clock when the defense brief came in, he was definitely not happy. And he's not happy this morning. And he will put it aside because he needs to, and I'm sure he will, and he won't let it affect the rulings on objections during the trial, because it affects Paul Caneiro's rights, no matter how unhappy he is with Monica. But it was interesting to have him say that he's told her things repeatedly in chambers or in camera at the bench. And she's keeping her head down, pretending she's looking at her laptop. She may be getting ready to give another argument. Somebody needs to give her advice as to when, even if you think you're right, to just stop making an argument. I see Paul's neighbor is in the courtroom again today. And they scanned the courtroom at one point yesterday, and I noticed that the people who are on the other side of the aisle are all sitting towards the aisle. So it does make me think that the way that courtroom is set up, to see the screen, to see the witness, and definitely to see the jury, you have to be on the side that we're looking at right now. All right. Bill Avita said, this has been brewing for a long time and the judge now unleashed for everything. I think that's right. The part of his reaction was all the times that she just, would interrupt him, would do what he just told her not to do. We're standing up. Does that mean the judge is coming in, or this officer just decided he's tired of sitting? He seems to be looking, though. No, nothing's happening yet. But So I think that's right. It did build up. But I think what happened would have gotten him very, very, very unhappy anyway. But I do think you're right that his general impression of her laid a foundation for how he reacted to this latest episode. So it's now 9:35. I should have, I keep saying I should look and time when he goes into chambers. I've been doing a better job of timing the breaks. By the time he comes out, we're going to have a break. And the jury's probably sitting, I know they are, they're sitting in the jury room wondering what is going on now. So how many of you think that the jury in the jury room may be guessing that it's something Monica has done that slowed the trial? Because I just wonder if they're getting that feeling. Okay. Amber is telling me she's going to do something to the screen when the trial starts again. So you'll see a different screen. Was Corey escorted out yesterday? If so, I missed it. Kathy Ruckman. A couple of people in the chat said yes. I didn't see it and I don't know. And I think they said a court reporter might have told someone, a reporter or a court reporter, I'm not sure which. And I don't know even if that source knew who Corey was or what he looked like. So someone could have said it and we still wouldn't know if that someone who said it was right. And I don't know. If this hearing is open to the public and Corey is not on the witness list, why would he have been removed yesterday? He's probably on the witness list, actually. Maybe not. But if he's on the witness list, he would have been escorted out. And if he's not on the witness list, he would not have been. So if he was there yesterday, and I'm not confirming because I don't know, and he was escorted out, then one should assume that he's on the witness list. That doesn't mean he's going to be called. You heard the judge. Not only do lawyers put more witnesses on than they end up calling because they don't know how the trial might proceed. And if a witness is not on the witness list, you may not be able to call the witness. So you try to cover all contingencies. And also, lawyers may put names on the witness list on the theory that then the other side is going to have to interview them and prepare just in case. So that's a tactical thing that lawyers do. But you also heard the judge say you put names on the witness list that you have no intention to call, and you're not doing it tactically, but it's because the judge, when it's voir dire of the jurors, reads all those names to see if there's any juror who is familiar with anyone who might be called or a name that might come up during the trial. And then the judge will pursue with that potential juror how well that potential juror knows the person and whether that potential juror would be affected by the fact that he or she knew the person. So the witness lists are always are much longer than the number of witnesses who are called. All right, well, it would have been interesting to see the faces of the gallery when the judge was stating his positions today. And he was clearly right on some of it. And again, I'll hopefully he's coming out soon. I will end where I started. This is a lesson for everyone that if you've got a rule and you think, hey, the way I'm going to live life is to get right up to the rule. Yes, it's even if you know that the reason for the rule would tell you don't do it, but you say, hey, the black letter tells me I can, that you really should think twice. That probably you should hold yourself to a slightly higher standard. And the risk, if you're too close to the line, oh, here we go.
Court is back in session.
You seen it? was an issue before the court yesterday.
I'm having trouble hearing
Summarized
him.
earlier in oral argument. But did not render a decision on the admissibility of the evidence when it was brought up at sidebar. Instead, the court expressed concern that the information, having not been previously disclosed to the state, potentially constituted a discovery violation. The court directed both parties to submit written memorandum addressing both the admissibility of the evidence and the discovery issue. After reviewing now the written submissions from the state and from the defense, and also listening to arguments this morning and a review of the applicable case law, court will render its decision now. First, I want to start with the premise under State versus Knight 256 NJ 404 2024, quoting State versus Williams 80 New Jersey 472, 478 1979. Quote, the thrust behind the reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. With that being said, in looking at our New Jersey court rule 3:13-3B2B requires the defendant to provide to the state, quote, any relevant books, papers, documents, electronically stored information, and any other data or data compilations stored in any medium from or through which information can be obtained. The phrase electronically stored information is broad and encompassing a wide range of digital evidence, but it includes and is not limited to text messages, emails, photos, videos, location data, metadata, and other information stored in electronic form. Rule 3:13-3F provides remedies when a party fails to comply with discovery obligations. The rule states, quote, if at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with this rule, the court may order the party to provide the discovery, grant a continuance or delay during the trial, prohibit the party from introducing in evidence or material not disclosed, or enter such other order as it's deemed appropriate, end quote. Critically, Rule 3:13-3F also imposes a, quote, continuing duty to provide discovery, end quote.
What I said.
In other words, discovery obligations do not end when initial discovery exchanges are completed. If a party learns of additional discoverable material at any point during the proceedings, including during trial, the party has an immediate obligation to disclose that material to the opposing party. In this case, the defense has relied on State versus Tier, where the Supreme Court held that Rule 3:13-3 does not require a defendant to generate a written witness statement where none exists. That's Tier at 228 NJ at 568. Tier protects attorney work product, specifically written summaries or notes that defense counsel creates during the investigation. The court in Tier emphasized that that compelling defense to create statements would invade the attorney-client relationship, reveal defense strategy and theory, and violate the defendant's Sixth Amendment right to counsel. The court did not address and specifically did not decide what obligation a defendant has with respect to independently created physical or electronic evidence that exists separate and apart from any work product created by defense counsel. In Knight, the Supreme Court addressed a question Tier did not resolve. What happens when independently created physical evidence exists and defense has access to it? There, the court held that an affidavit not created by defense counsel must be disclosed under Rule 3:13-3B2B. The court indicated, quote, the affidavit is physical evidence of a crime. It's not the product of the defense investigation or attorney work product. Rather, the affidavit is a relevant writing, potentially in defense counsel's possession, pursuant to Rule 3:13-3B2B. There is no question that this type of physical evidence falls squarely within the defendant's required reciprocal discovery obligations. That's Knight 256 NJ 404,422 2014. The court distinguished previous cases before the court in State versus Mingo and State versus Williams of turning over inculpatory evidence. The court in Knight also rejected Sixth Amendment concerns. Quote, no such concern is present in this case, however, in which the item in question is physical evidence and not the product of defense counsel's investigations. That's Knight at 423. Significantly, Knight uses the phrase, quote, potentially in defense counsel's possession rather than actually in defense counsel's physical possession. In this case, we know that defense counsel physically had possession of a screenshot of a communication between Caitlin Caneiro and Jennifer Caneiro, where the document specifically shows that at some point in time, the text message was read. That item was never turned over to the state at any point in time until well after the testimony. The court now applies this legal framework to the two pieces of electronic evidence at issue in this case, beginning with the text message screenshot. Here, the text message screenshot depicts electronic metadata showing that a message sent by Katie to Jennifer now displays a status of, quote, read, end quote. First, as to the origin of the screenshot, the, quote, read, end quote status was created by the iPhone messaging system, not by defense counsel. When Jennifer Caneiro's phone or other device logged into her iMessage account, opened Katie's message, the messaging system automatically generated the, quote, read, end quote status and transmitted that information back to Katie's device. This is a function of how the iPhone iMessage system operates. It's not something that defense counsel created, directed, or had any role in producing. Similarly, the screenshot itself was created by Katie Caneiro, not by defense counsel. Katie took the screenshot on her own phone and then transmitted it to defense counsel. Under Knight, this electronic evidence, quote, falls squarely within defendant's required reciprocal discovery obligations, end quote, because it is, quote, not the product of defense investigation or attorney work product, end quote. Second, as to the discoverability, the text message screenshot unquestionably qualifies as electronic stored information. It is a digital image file depicting electronic metadata from an iPhone messaging application. It is stored on Katie's phone and was transmitted electronically to defense counsel's phone or computer. This is precisely the type of electronic evidence that Rule 3:13-3B2B contemplates. Moreover, defense counsel actually received that screenshot on February 8th, 2026, according to defense counsel. Defense counsel had that screenshot in her possession when Katie testified on February 9th, 2026. Thus, defense counsel had actual physical possession of the electronic file. The fact that defense counsel chose not to introduce the screenshot as an exhibit at trial does not change the discovery obligation. Defense counsel's strategic decision about how to use the evidence, whether to present it through testimony describing it or through introduction of the exhibit itself, does not eliminate the requirement to disclose it to the state. It's Discovery Rule 3:13-3B2B. Finally, the defendant's argument assuaging noncompliance are unavailing. Under Rule 3:13-3F, there is a continuing duty to provide discovery. The fact that the defense counsel received the screenshot only one day before Katie was scheduled to testify, according to what she has said, does not excuse the failure to disclose. Further, the defense's reliance on TIR misunderstands the distinction between TIR and Knight. TIR protects defense counsel from being compelled to create written summaries or oral written statements. TIR does not protect defense from disclosing independently created evidence that defense has the ability to obtain and had it in her possession. Because the screenshot was created by Katie and the messaging system, not by defense counsel, Knight requires disclosure regardless of whether defense counsel ultimately introduces it as an exhibit. Therefore, this court finds the defendant violated its discovery rule obligations as it relates to the text message read status of the text message between Katie Caneiro and Jennifer Caneiro. As to the GPS, the iPad location data was created by a location sharing service or application, not by defense counsel. While the parties have not identified the specific service Katie used, common location sharing services include Find My Phone by Apple, Life 360, Google location services, and similar applications. These services use GPS technology to track the location of devices and share that location information with authorized users. When Jesse Caneiro's iPad shared its location with Katie's device, the location sharing service generated GPS coordinates, timestamps, and other metadata showing where the iPad was located at various times. This data was created by the technology, not by defense counsel. Defense counsel played no role whatsoever in the genesis of this electronic evidence that was created by the witness's actual iPhone. First, location sharing data is unquestionably electronically stored information within the meaning of Rule 3:13-3B2B. The rule specifically requires disclosure of electronically stored information and any other data or data compilations stored in any medium. Defense counsel states that the defense simply has what was verbally relayed during a recent witness prep session. However, the test under Knight is not limited to evidence that defense counsel has already obtained and is physically holding. Knight uses the phrase, quote, potentially in defense counsel's possession, end quote, indicating the test extends to evidence that the defense counsel has the ability to obtain. Defense counsel argues that TIR protects Katie's testimony about what she observed because defense counsel has no written statement or document to turn over. Defense counsel contends that Katie simply told counsel orally what she saw, and TIR holds that defense counsel need not create a written summary of the oral statement. This argument fails for the same reason it fails with respect to the text message screenshot. The issue is not whether defense counsel must create new work product summarizing what Katie said. The issue is whether defense counsel must obtain and disclose independently created electronic evidence that exists separate and apart from any work product, or at least to ask about it. Caitlin Caneiro did not merely remember seeing something. Katie used a location sharing service that generated electronic data. That data exists or existed in electronic form. It was created by technology, not by defense counsel. If defense counsel had the ability to obtain the data from Katie, then defense counsel should have requested it or at least indicated to the state that it does not exist. TIR protects, as I indicated, work product created by defense counsel. TIR does not protect defense counsel from the obligation to obtain and disclose independently created electronic evidence within defense counsel's control. I should also point out, as it relates to the location sharing, that defense counsel indicates in a footnote on page 2 of her brief that she must have learned through her conversation, I'll just use her words, It should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it, either via text message or phone call, once she saw that she had the location, and asked him why he taken Jesse's iPad. Why he had taken is probably what she meant to say. Corey then turned off the location. However, so in that circumstance, that is more information that if the state had that information in advance, would have had the opportunity to actually investigate whether that phone call or text message actually existed, had the opportunity to reach out to Corey Caneiro, and if they wanted to or so choose to figure out if that existed, to get other phone records in this particular case, which at some point they did not feel that they needed at the time that they originally interviewed her. What happened here is that defense counsel put the state in a position by not providing any information as it relates to that metadata for the location services, puts the state in a position where they did not have the opportunity to even investigate, which is exactly what I said from the beginning, that State versus Knight talks about, that the thrust behind reciprocal discovery rules is that the state is entitled to know in advance what evidence a defendant intends to use at trial so that it may have a fair opportunity to investigate the veracity of such proof. Okay. So with that being said, defense counsel devotes substantial portions of the written submission to arguing that Katie Caneiro was available to the state for more than 6 years, and that if the state wanted to learn about the evidence, the state could have re-interviewed Katie at any time. This argument fails to excuse the discovery violation for several independent reasons. Number one, discovery obligations are independent of the state's investigation. Under Rule 3:13-3B, it imposes discovery obligations on the defense that exist independently of what investigative steps the state has or has not taken. This rule does not contain an exception stating that a defendant need not disclose evidence if the state theoretically could have discovered it through independent investigation. If defense counsel's argument were accepted, it would eviscerate the reciprocal discovery rule. Under defense counsel's theory, a defendant would never have to have a discovery obligation with respect to any evidence that the state could have found on its own through a diligent investigation. This would include written statements, documents, physical evidence, and electronic data. The defendant could simply wait to see what the state discovers and then spring any additional physical evidence or electronic data, arguing that the state should have investigated more thoroughly. Second, the evidence did not exist when the state interviewed Katie. Defense counsel argument in that area also fails. The state interviewed Katie Caneiro on November 20th, 2018, the day after the murders. At that time, the text message did not yet display a read status because Katie had not yet checked it after Jennifer's death. At the time, Katie had not yet tracked the iPad location of Corey's residence because it did not occur until February 2019, several months later. The state cannot be faulted for failing to ask Katie about evidence that did not yet exist at the time of the interview. The notion that the state should have conducted follow-up interviews with Katie every few months for the next 6 years on the speculation that she might someday check our old text messages, track an iPad location is unreasonable, and this court finds no support in law. Defense counsel argues, as a third point, that it would be unfair to penalize the defense for recently learning information that the state could have discovered years ago. This argument actually supports the state's position rather than the defendant's position. If the timing of when parties learn information matters for purposes of fairness, then the relevant comparison is not between when the state first interviewed Katie in 2018 and when the defense counsel interviewed Katie in 2026. The relevant comparison is between when defense counsel learned about this evidence and when the state learned about it. Defense counsel learned about the iPad location on either January 30th, 2026 or February 8th, 2026, based upon defense counsel indicating that she had prepped Katie Caneiro for the first time for her testimony on these two particular dates. Defense counsel obtained the text message screenshot on February 8th, 2026. Katie testified on February 9th, 2026. Defense counsel had somewhere between 1 day and 10 days to disclose not just the evidence for the text message, but also the iPad location information so that the state could have had the opportunity to take a look at it and investigate it. The state has literally had zero time to investigate any part of this information, to verify it, to contradict it, to subpoena for more information, or anything in that matter. If fairness and timing matters, as defense counsel argues they do, then the fair result is to give the state the same opportunity to investigate that defense counsel had. That is precisely why the continuance would be accomplished if it was requested by the state. There are questions here that the state cannot answer simply through cross-examination of Katie Caneiro. These questions potentially require investigation, consultation with technical reports, forensic evidence of Katie's phone, review of service provider records, and potentially interviews of other witnesses, including Corey Caneiro himself. The state cannot conduct this investigation while Katie is on the witness stand testifying before the jury. The state would need time to investigate before the evidence impacts jury deliberations. The state has indicated before they heard my decision that they would that they did not want a continuance for any reason. However, before I finish this opinion, I'm going to give them the opportunity, after hearing the opinion, to make any decision that they would like to make. The court is relying on 3:13-3F, where the trial court is afforded wide latitude to resolve discovery disputes. Moreover, in appropriate circumstances, the court can either order discovery of items beyond the scope of the discovery listed in Rule 3:13-3. However, in this case, under the circumstances, the court is not going to use the draconian remedy of actually barring some of this evidence, and I'll go through it in a minute, but the court would consider a continuance for the state if they needed more time.
This is because it's the defense that did it. If it was the state,
however, let me
just bar
say
the
this.
evidence.
As it relates for the rationale behind the reasoning for the GPS testimony, which
That's why it's really unfair to the state, because the state doesn't have a defendant with a Sixth Amendment right. If it were the reverse, I'm confident that he would just have excluded the evidence.
this testimony is relevant because, and this is relating to the GPS location of where Jesse's iPad was located, for two reasons. One, it demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Boat's Detective Boat.
Now what happened? Phone? Did the phone go off?
My apologies, that was the third time.
Can we go off the record for a second?
Judge Off White.
So he's saying scene contamination, and that's a little hard to understand since it was post-homicide. I guess we'll have to find out when Corey, do we know when Corey took it? that was the question I got from the chat earlier. When was the house released, when the investigation was over?
Okay. For the record purposes, an individual was removed from the courtroom for reasons for the sheriff's department to take care of. I just want to go back and say for the two reasons why the defense believes that this is admissible. The GPS locations. It demonstrates that Corey was taking items from the house after the homicides, which lends further credence to the defense's earlier point regarding scene contamination during the cross-examination of Detective Vogt regarding the Tiffany's jewelry boxes found on top of the fire rubble, both of which occurred prior to Vogt's collection of DNA samples in 2020. Second, that it demonstrates a failure to investigate for whatever reason. The police did not seize or search the iPad, while they did seize or search Sophia's phone. I will take them in order. As it relates to any type of Corey's taking of these items out of the house after the homicide, the court had rendered a decision on January 27th, 2026 in a 42-page opinion outlining what behavior that and what instances that would be allowed to be elicited by the defense of either Corey Caneiro or if there were certain other witnesses that took the stand as it related to Corey Caneiro. The court in that order court specifically said that it was found as wholly inadmissible any alleged post-crime suspicious activity involving Elisa Caneiro and Corey Caneiro. In this circumstance, the allegation that Corey went into the home and took out the iPad allegedly, because at this point in time, there's testimony about a GPS location. I don't know if the state's going to end up asking for for a period of time to actually look at the witness's phone to find out if the GPS actually is there or not. But right now, we only have testimony about that. And the reality is, I have no evidence in this case other than that at some point in time, potentially, Corey had Jesse's iPad. I was supplied in the submission by the defense a photograph of the kitchen of Keith Caneiro's home that had an iPad there. That iPad, whether that's Jesse's or not, that's what is being offered by the defense, that it's Jesse's, and that Corey may have taken it. But Corey also was responsible for taking over everything after Keith and his entire family was obliterated from this planet, and Corey was left to handle all of the issues that were relating to the estate of this. So I can't find under these circumstances that Corey taking items from the house is relevant. I find that under 403 that it actually would be a confusing issue for the jury, because the probative value is significantly outweighed by the prejudicial effect of trying to understand first, was it Corey that actually took it out of the house? Was it somebody else that took it out of the house and gave it to Corey at some point in time? Was it, who knows? The answer is that no one knows that. There's no testimony to that. There's no connection that has been shown, at least at this point in time. So the fact that the allegation is that Corey took items out of that house is not something that this court finds that would overcome a 403 analysis. The second issue is one that's something that's more in line with what I can understand. The second issue deals with a failure to investigate because the police did not seize and search the iPad while they did seize and search Sophia's phone. As it relates to what the investigation revealed and what it may not have, what they did and what they didn't do, that is relevant overall in this particular case. The issue in this case is whether there was other evidence in this case that would point to a different individual other than Paul Caneiro, and the investigation and looking into other areas such as the iPad, I do find to be relevant. I do not find under 403 that its prejudicial effect would be outweighed by the probative value. So I am going to, for purposes of this testimony, I will allow the fact that the iPad has been was taken out of the home. However, the testimony as it relates to the GPS location is something that I'm going to strike from the record. There is no relevance to that other than under 403 as an overall thing, that there would be a confusion, that the prejudicial effect because of that confusion outweighs any probative value. So we can handle that in one of a few ways. Number one, there can be an agreement that Jesse's iPad, that there can be a stipulation that Jesse's iPad was not searched, was not taken and or searched, or some other type of stipulation that you can come up with. But there will be no testimony as it relates to this iPad until someone can give me a proffer in advance of exactly what's going to be said about it. Defense counsel, out of fairness to the defense, offered up some suggestions. I'll leave it to the state and the defense if they want to come up with something that would be that they feel would be fair to both sides. However, the admissibility of the GPS location as it relates to the two reasons why that the defense wants to bring it in, the court does not find under those circumstances that it would allow the GPS location in. Again, it will allow the fact that the iPad was not seized or searched, but as it relates to GPS location, this court has difficulty with understanding how there is a connection between where the iPad was located, especially when the defense is specifically saying in their submission that they are not saying that the iPad was taken during the murders, that the iPad was located still at the house after the murders, that there's no connection to Corey Caneiro or third-party guilt as it relates to that particular iPad, that I do not find a connection there under Codaditch, and I would not allow that in for purposes of any third-party guilt. But like I said, I would consider it for purposes of a failure to investigate. As it relates to the text message, as I indicated, I'm going to ask the state now if the state would like some time to investigate and or whatever that they need to do. I would entertain that. If the state decided that they did not want time to investigate, I am going to give them latitude as to the cross-examination in this specific area of the witness as it relates to that screenshot and how it was provided, when it was provided, and how that all took place. So with that being said, that's the court's decision, that even though I do find discovery violations on both, I find that under these circumstances, that the draconian remedy of excluding them for the reason of a discovery violation is not what this court is doing. However, in looking at the actual items, I have made rulings as it relates to my understanding of the evidence rules and how it should be allowed in or not allowed in. So with that being said, to the state, I'll give you the opportunity to let me know if you want what your preference is under the circumstances, and also if you want some time to speak to counsel as it relates to a stipulation as to the second part of Jesse's iPad.
Sure, Judge. I think Ms. Wallace is going to talk to Ms. Mastalone about the iPad. I'm going to go inquire. I highly doubt I'm going to ask for any more time other than 10 to 15 minutes just to think about it.
Okay.
The only question I had, Judge, with respect to clarification of the
Sure.
court's order, obviously they heard it was read, part of that testimony, but we got that document in the brief last night. Is the defense allowed to utilize the actual screenshot?
Well, let me ask you this question. Does the state, under the circumstances that it's been put in, would you want to use that on cross-examination and to go in the circumstances surrounding that testimony that you already have? Because as I indicated, I'm going to give some latitude because of the fact that I do find it is to be a violation, but I do find that under these circumstances that I'm going to allow it in because somebody opened it. It's already out there. And I don't think that I can clear that out of the jury's mind. And I think it's really at this point in time, the preference of the state. And again, if you want a few minutes to think about that, I'll give you the opportunity to do it. And again, if you need more time, then all you have to do is ask for that. And out of fairness, I would give you that opportunity to have more time. I don't want anyone, either side here, to sit here and worry about the trial and how long the trial is going or how quickly it's going. It's truly your own prerogative for the state, and you and Ms. Wallace should have the opportunity to think about it now that you have my decision.
Okay, Judge. Yeah, I would just like a little bit of time to think about that.
Okay, well, why don't we meet back here at 10:45? I'll give you 30 minutes. If you need more time, you can let me know. We're going to tell the jurors downstairs we're in a little bit of a holding pattern, and I'll have them more do that. I won't address them myself, just to let them know so that they get an idea of what's going on. Okay?
Thank you, Judge.
All right, thank you.
Okay, we're on a break. This one I understand, actually. Some of the other breaks were a little more confusing to me, but this one I do understand. Since they're going to, and I think they should have asked for an hour to really talk about it and decide, which would have taken us to 11:20 and probably through lunch. So what do you think? Are they going to ask for it or not? A continuance to look into it. He said he highly doubted it. What do you think? What's happening? They're giving the state time to decide whether they want a continuance to investigate the information with regard to the text message or the iPad. And then they're going to have to say how much time they need to do it. But it would really be the information in the text message, not the location of the iPad. And so that's what they're doing. Do I think she got off easy? I think well, we don't know what's going to happen to her. I mean, somebody could file. I doubt that they will. She got a dressing down. She's got a judge who's never going to trust her. She's got a whole prosecutor's office that probably is not going to trust her. So I don't know whether we would say she got off easy or not. But the fact that he's going to allow some of the evidence in is not a surprise to me. As I said earlier, if it had been the other way around, he probably would have said the state could not use it. But the defense, because of the defendant's Sixth Amendment right to a fair trial, I thought it was pretty clear that the judge was not going to keep all the evidence out. So he sort of split the baby, and he's allowing in what was already in the record now because she had already asked the questions. And so she will be able to get in that the iPad was removed from the house and when, to show that the investigation wasn't done well enough, but she won't be able to get in where it was found or how it was removed from the house. So that's probably not a bad compromise, and I don't think it hurts the state that much. Oh, somebody had a problem. So I don't see any questions here. Let me escape from full screen. I don't know how I got in full screen anyway. I think it was probably, I want to escape from full screen though. Oh, there we go. There we go. All right, I don't see any questions. I did predict it, didn't I? Did I? I'm not even sure. But I may have, yeah, because it's pretty, that's not, no kudos to me because I think any lawyer would have come to the same conclusion. Okay, will this sway the jury to have doubt about Paul being the killer of Corey? I don't know. I mean, all they're going to find out is that the laptop was removed from the home after the law enforcement had finished, and that the laptop was not investigated to see what was on it. I don't know how much that means. I mean, the home is not secured, and the fact that it's not secured means anybody could have gone in and tried to take things. Doesn't have to be a family member. And Janet True is saying Corey was the administrator. February was 3 months after the homicide. The state could make it clear and cross. Sure, the state can do that. Absolutely. I don't know that it's going to talk about Corey being the administrator because there is no evidence that's going to go in that Corey took the laptop. So I don't know that the state wants to go down that road since there's no evidence as to who took the laptop. But we'll see. And I think I'm going to shut us off for a few minutes while we wait for this latest event. Since the jury is coming in, I'm guessing the state decided not to ask for a continuance. Although it is possible. I don't like me looking big and the trial looking small. Nope. How do I fix this? There you go. I prefer that. Although it's possible that the jury's coming in so the judge can tell them, well, guess what? You came in at 9. You've been sitting in the jury room for 2 hours, and now I'm sending you home. But I'm guessing it's not that. It's going to be, well, there you go. I moved the cursor. Oh, there it is. Do I think the judge wished the prosecution had requested continuance? No, I think he wanted he wanted to give them the opportunity, but I don't think he had what would it be, an oar in this water, or whatever the phrase is. I think he may think if he was prosecuting, he might have asked for one, but I think he will rely on the prosecutor to decide. He just wanted to give the prosecutor a full opportunity if the prosecutor wanted it, and not to worry about the delay in the trial. I mean, he made that clear. Don't worry about that. We're ahead of schedule. Okay. So here's Murder by Maestro. I can't help but wonder if Monica was more seasoned or had a history with the judge and better rapport, he might have had a slightly different attitude. She is seasoned. She's not a new defense lawyer in that office. She's the supervisor in this team. So she's been doing it for a while. She's not she's not a young new lawyer by any means. And And I don't think, well, I think his attitude towards her developed because of the way she proceeded in this trial from the very start. In voir dire, she got up on her feet and told the judge that she would like to do the questioning of the jurors. I think this is right. Her request was to do the question of the jurors one by one, sidebar. And she said, it may sound unusual to you, but I've made this request of judges before, and it always sounds unusual until they hear my explanation, and then they decide I'm right. And the judge said, well, I've done a lot of trials too. I don't do it this way, and we're going to go my way. So that attitude, which was way back in voir dire, permeated the trial, and he would make rulings that she would ignore. We all saw that. So I think she created the atmosphere with the judge. It wasn't that he came in with any fixed notion about her. She did it to herself. I mean, think of how we react to her in the chat. And she's not respectful. She talks over him. She interrupts. And you don't do that to a judge. So I think she brought it on herself. But I think even if there hadn't been any of that history, this episode of how she was trying to manipulate and get around the discovery rules would still have provoked the response that you saw from him. He might have been a little more measured. He might not have shouted at her, but I think it would have been the same thing because she did try to get around the discovery rules, at least in my view, and she didn't get away with it. And no past experience at all, and a judge would not be happy. Melissa Navon asks if they ever get monetary sanctions. You mean the lawyers? Yeah, the judge can hold a lawyer in contempt and then impose a fine. It's really rare. Very, very rare. So I doubt he will do anything, but he might, because I think he's had it with her. He might. He might also, and judges don't usually do this, call the public defender and issue his concerns with the public defender. Okay, state mostly can't get a do-over after verdict, but the defense can, right? Right. The defense can always appeal after a verdict, not that the defense can try. It always can. And the state never can because of double jeopardy. Now, my comment about the state never can, Agent 47, is a little unnuanced, but that's too long a subject for me to go into it. So, and the general rule is the general rule in 99.5% of the cases. Agent 47 wants to know if I would ask for a continuance if I were the state. I can't answer that because I'm not close enough to the facts in their case and what they know that they might find if they did further investigation, and their calculus as to whether it's worth it based on the information. On just that latter part, if all the jury heard, and I'd like to hear the end of yesterday's testimony again to confirm, but if all the jury heard was nothing that mentioned Corey at the end or suggested Corey at the end, then I think the judge's resolution would have been okay with me. And that is that you can't talk about how that iPad left Keith's house or who might have done it or how it was done. But you can use the fact that it left to suggest that the investigation could have been done better. And that's the claim they're making anyway, and I think the state can handle that. So I think that's where I would come out. But as I say, I don't, it's very hard to do these things when you don't know what else the state is looking at, where, it may see some disadvantages to pursuing it. And if you have to pursue it by putting Corey on the stand, I don't think I would do that. So Angela Thompson, I just sort of gave my view of it. Okay. Well, I thought we were going. Didn't you hear the jury? I could swear I heard the jury. I don't know. It was somebody in the gallery, and I don't know what he did. I didn't hear a phone I didn't hear a phone go off, which is normally the thing, although they haven't been moving people out because of, a phone. Maybe he shouted something. If so, I didn't hear it. Okay. Do I think that the judge saying Keith and his family was were obliterated was prejudicial language? Well, the jury didn't hear it, so the jury wasn't prejudiced by it. I assume that the defense on appeal, if Corey is convicted, can say that language evidences the judge's bias or the prejudice against the defense. And there have been other episodes during the trial. But I don't think that will go anywhere because he was pretty exasperated and the jury wasn't there to hear it. Have I ever seen a dressing down like that? You mean in court, Maestro? No, but it would be rare. And I'm not suggesting it never happens, but it's so rare. You'd have to be watching that trial or in court that day. You're not going to see it every day of the week. And it was quite the dressing down, but partly it was because after he told her, she started out, asked her a yes or no question. She didn't want to answer it yes or no. And that's when he started to get, as I recall, that's when he really started to, I'll see tonight, but it seemed to me that's when he really got very, very, let's say, unhappy. And he finally made her answer yes or no, and then she went on to talk anyway. And then she wanted to explain why it wasn't really electronically recorded because she never had it. And the law's against her. And so she kept pushing the way she pushes when she's trying to question witnesses and she gets a ruling against her. She doesn't stop. And she did it with him and he didn't like it at all. Do her actions affect both defense attorneys' credibility in the future? I don't think it affects Mr. Murray because I don't know how involved he was in this decision, but it certainly will affect her reputation with the judge, with other judges, because you're going to bet he's going to talk to other judges about it, with the state. And this is going to be talked about. So yes, it will affect. I could swear, did you hear the jury come in and now we're having a sidebar? And my mother would say she has a puss on her face now. That was my mother's description for her facial expression. Would all this, Carolyn Walsh wants to know if it will make it easier as a ground for appeal. And did she do this on purpose? Well, she did it on purpose and thought she was going to get away with it. She didn't do it on purpose to create a ground for appeal. That's just an I see that question a lot, but that would be an extraordinary thing for a defense lawyer to do because you don't win very many appeals. So I don't think a defense lawyer would ever do that. But she certainly did it on purpose because she thought she could get away with it. Is it a ground for appeal? Sure. Did the judge create a great record for it not being a successful appeal? Absolutely. You heard the opinion he gave from the bench, and he went through it thoroughly, his reasons why. The cases, he talked about 2 cases, and another case was cited in one of them. He referred to the court rule. He asked her to agree that it was an electronic transmission and under the rule, and she finally did, but then she went on to say she didn't think it applied here. I think he did a great job with the record, and I doubt very much that any appellate court would look at it and say there was any error at all. And he's allowing part of the evidence in, notwithstanding the discovery violation. So I don't think it'll be a successful ground for appeal. Okay. But I think it's interesting, if I'm right, that the jury came in, and I think I heard them, that now they're doing sidebar. And I thought her comment, which I think probably made him even angrier, but her comment that she's doing more sidebar than she ever had to do in order to clear things with her was a little disingenuous, because a lot of the sidebars are after she has been told she gets a ruling against her on something and then doesn't want to accept it. And that's when they go sidebar. And she asks for the sidebar. And he put the eye rolling on the record too. Yeah, he was out for he sees this as maybe an appealable issue, and he really nailed it. Okay, somebody told me that it was Ski Bump JMJ was trying to hype my channel for 3 hours and finally was able to do so. Thank you very much. Maybe she didn't say 3. Oh no, it was 3 hours ago that you said it. I thought for 3 hours I wouldn't ask you to do that, but thank you for hyping. And while we're all sitting here waiting, you could take your little finger and hit subscribe, or your little finger and hit like. Would only cost you a little, just a little movement by your little finger, and I would appreciate it. And it wouldn't interrupt anything else because we're having another sidebar. So that was my comment. But I really wish I knew why we're waiting again. This is just peculiar. So tonight in the, your mother used the same expression. Must be a New Jersey Italian mom phrase. Could be Catherine Talbot. We're going to do the recap a little later tonight because I want to get a little more organized with this one. And we're going to run some clips from the trial today, from the hearing today. So you might tell your friends that this is one where they might very well. Yeah, I did say even slam the door because he did. He slammed the door. That this would be one to watch. For those of you who watched it once, you may very well want to see it again. But tell your friends that this is coming, because I think anybody who's a trial watcher would find what happened today very, very interesting to watch, even if they're not watching the Caneiro trial. So, and it would be nice to have a lot of viewers watching tonight. So I have a self-interest in this, but it's self-interest, but it's also altruistic, because I can't imagine anyone who wouldn't find it, let me say, edifying to watch it. Okay, murder by maestro. Why did the judge just allow Monica to disagree with his ruling, put it on the record, and move on? Because she didn't. He asked her to agree that it was an electronic, I don't know what they call it, but electronic under the rule. He wanted her to say that on the record because it helps when the record in terms of what he's writing. And she did not want to say it. He also wanted to give her a chance orally. Note, I said orally, not verbally, because she did verbally when she wrote the brief or whatever, the memo. He wanted to give her a chance orally to amplify what she had written the night before. And that, again, is for the record. You don't want on appeal the appellate lawyer to be able to say, well, he never gave her a chance to explain. You want to take that out, any argument out. And so he did give her a chance to explain, and then got more annoyed at her because he told her what he thought the rule said, and she wanted to argue it. And I think on my reading, and I only spent about 15 minutes on it, but my reading plus what I know of discovery rules, I think he's absolutely right. But even were he to be wrong, there's a point if you're the advocate that you stop arguing with the judge. You record your objection and disagreement, so you've got so you can raise it on appeal, but you don't keep arguing it. But she has not learned that. She argues with witnesses, she argues with the judge, and she does it at a point at which there is no good reason for doing it and very good reason for stopping. Okay. This is a long sidebar. Did somebody tell me in the chat, did you hear the jury come in, or it was my imagination? Because there's no reason to bring the jury in and then have a long sidebar. Imagine if you were on this jury. You came in at 9 today because the judge had said he had some legal issue to handle. And then you don't come out at all. And then you come out, if I'm right that I heard him. And what happens? You sit in the jury box and they have a sidebar. You'd have to think that there's something peculiar about the justice system off this trial. So 1016 Deb says she agrees with me totally, and I love that. I don't know what it is that I said that she agrees with, but I love it when people agree with me. Okay, so Scotch's mom didn't hear the jury come in, but Ella thought she did. Beach Bum wants to know if the judge can tell the jury some of what happened. No. The judge will just say it was a legal issue that had to be decided. He can't tell them what happened if it's information that they're not going to hear. And he's not going to tell them what happened if it's information that's going to come through the witnesses.
Sure.
No, he'll say it was a legal issue and he's sorry it took.
Ladies and gentlemen, we're going to break to give the state a little bit more time. We'll start back up at 1:30.
Oh, and look, he is not a happy camper. And I don't think he's angry at the state. I definitely don't think he's angry at the state, because he'll give them all the time they need. Hit the door again. All right, well, we're off. It's 11:15. What did he say, 1:30 or 1? I'm so busy talking, I forgot to listen to what he said. Who knows? 1 or 1:30? Nobody's going to tell me? 1:30. Okay, thanks, Scotch's mom. Okay, well, we're coming back at 1:30. I don't see any questions in here. So you can have a nice, long, leisurely lunch. You can go take a walk if it's not too cold where you are. You can ponder what happened so far. I would say you could re-look at this, but I don't think you can. While it's still live, I don't think it gets posted as a video. But you can look at yesterday's video and scroll it to the end and see what it was that the question and answer was that provoked all this. And then you would be, better prepped for what happens after lunch. So in any event, I will see you all at 1:30. Ciao a tutti. And hit live and hit subscribe while you're on your way out. So long for a little while. Hello, I hope you all had a good lunch. And although it says court will return at 1:30 p.m., on my clock it's 1:33, so things are back to normal. And I see that there's been a release of the photos from Nancy Guthrie's house. You're having a chat about it. That's another terrible case. Although I think kidnapping is a very, excuse me, silly crime. I mean, it's an awful crime, but it's silly because it's like a kidnapper sends a note to law enforcement and says, at a certain time in a certain place, here I'll be. That's the way it used to be when you had to pick up the ransom money or whatever. But I'm not sure how different it is if you deposit the money somewhere. They still can be waiting for you to pick it up electronically and maybe find a path. Oh, Lauren said the judge came out a few minutes ago, talked, but there was no sound. Then he went back. These camera crew. I wish I had a camera crew and a mic myself, but I don't know how much that would cost. Probably a lot of money, and more than I can afford to give to this cause, more than what I already do. But if I had one, I would certainly operate it more efficiently than what we see here. I would certainly train the camera people as to what they should focus on. I know they probably wouldn't like that because they consider themselves experienced, but I would anyway. So Amber says, check out my coffee. I'll hold it up because it's not up right now. Here you go. It was one of the Christmas gifts from my family. And it's backwards. You can't see it. My camera at least shows it in reverse, so you would have to take a picture, a screenshot, and then put it up against a mirror, or you have to be good at reading. You'd be an old printer. Old printers used to have to set type like this. In fact, I think they had to do it upside down and in reverse, and they got pretty fast at it. Then sort of online, so not online, offline. No, what did they call it? Offset, where you didn't have to set type. And so the skill of being a printer pretty much evaporated. Thank you, Beach Bum. Yeah, I thought it was cute. They gave me a t-shirt and a hat too. And there was something else, a t-shirt, a hat, there was something, and then the mug. They were very proud of themselves for thinking of these as gifts. Oh, it was reading correctly for you? Well, then why on mine was it backwards? I don't understand. See, my electronics just decide to be perverse with me. Often they attack me. And sometimes they sit there and do nothing when I need something. They're just very cruel. Amber says it's a StreamYard thing. It is great advertising, isn't it? Well, the hat will be. I'm going to wear the hat in Sorrento on my head. Well, of course I would wear it on my head. That was a really bright comment, wasn't it? But it does remind me that when my niece was 2, a little over 2, I got her, I don't know I don't remember the name of the company that does it, but they're dolls and they're magnetized clothes that you put on them. It was the modern version of cutout dolls. And it had about 200 different outfits. And she insisted on putting the shoes on the cutout doll. There were 3 cutout, on the head, and she knew better, but she just thought it was a hoot that I kept telling her that shoes didn't belong on somebody's head. And when had she worn shoes on her head? So she just thought she was being the cleverest thing. But my telling you that I was going to wear the hat on my head was hardly clever. Well, it was a nice, from my family. Well, yes, it was nice and it was thoughtful, but they also thought that they were being really funny. And that's what motivated them. But they had to get it, they had to design it and get it ordered. So yes, very nice and thoughtful. Merch can't be far behind. I don't know. People don't hit like, they don't hit subscribe. I think you have to have more members before you go into merchandise. Although I have some good ideas about merchandise. Mine is different because I'm the creator. I'm not the creator, they were. The judge is doing vocal. I need the vocal warm-ups. The judge is doing vocal warm-ups to continue yelling if needed. Well, he didn't really yell. I mean, I can yell. That was not yelling. That was a very harsh voice spoken in a tone a little louder than normal, but it wasn't yelling. You couldn't hear him across the street. That's what I consider yelling. Paper dolls were the bane of your existence. Pink slippers, they would never stay on. Well, what I found was it took so long to cut out the dresses and those little notch things. You had to be so careful, otherwise they would tear off. You're right. But the ones that they do now where they're magneticized, you don't have to take all the time to cut, and they just stick right on. They're much better. I don't remember what the name of the company that does them, but they do a lot of things. You find them in Whole Foods. It's somebody and somebody, 2 names. That's the best I can give you. And the one I got her had 3 dolls and at least 300 items of clothing that you could mix and match. And she just loved it. I did too. In fact, I thought about going out and buying myself one also so I could play on my own, but I never got around to it. Pink Slipper said it was yelling, and he was definitely angry. Oh, I agree, Sanders, that he was definitely angry. So I guess it depends on with whom you grew up to decide whether you think it's yelling or not. So, and in my world, that would not have been yelling, because when people yelled, they yelled. But we can agree that he was very angry, and he was still trying to keep himself under control. Oh. Cynthia hopes the defense attorney learned her lesson, but fears not. I don't think she did. I'm not sure it's in her. Because if it were in her, she would have stopped being combative with him much earlier, and she would just have said, we're going to have to disagree, but I hear what you say, and you're the judge. And she didn't. Well, she didn't. You watched what she did. She also, I've been thinking about it, even the way that's right, not yelling, I'm Italian, that's exactly right. Even the way she walks is a very, it's almost a strut. And when she sits at counsel table, she usually doesn't sit straight on. She turns her chair and crosses her knee as though she was the one in charge. She's a case study. Joe, Dale Warner trial starts. Went away on Thursday and is being streamed on Court TV. Well, this one is certainly not going to end on Thursday. Let me just share with you in case you disabuse you, in case you think this one will be over. But thank you very much for telling me. Monica got exactly what she wanted, so there's no lesson learned. She actually didn't get exactly what she wanted. She also wanted in the fact that the iPad was found at Corey's house, and that Corey was the one who took it, and she's not going to be able to ask any of those questions. She got no more than she would have gotten anyway if she had followed the rules and provided discovery. And she got a chastising from the judge, which is going to travel around that law community. There's no doubt in my mind it will travel around the law community. So her reputation, she's going to say she was an avid advocate, zealous advocate, and the judge was wrong. But there are people who know her, and the people who can watch this video And with some of the publicity and what people report, some lawyers will. So she did not come out where she would have if she had done it the right way. Ling 35, thank you. My necklace is unique and I share the origin. I bought it online. I'll have to think where.
Look, I think we're ready to continue with the direct examination of Ms. Caneiro.
Okay. Have we come to an agreement as to when we're going to deal with the stipulation issue?
I think before we leave for the day, we can give that to the court. I mean, I think it's one of us just has to write it out.
So no continuance.
All right. Defense, anything else that we need to put on the record before I bring out the jury?
Not at this time, Judge.
Okay. You can ask the jury to come back out, please.
And they're going to try to do a stipulation. Now we're all going to watch like hawks. If she manages to ask a question or come near a question she's not supposed to ask. Melissa and Doug, that's right. Thank you, Clancy Riley. That's who they are. You think you she'll get more clients from this? If I watched this and I were to hire a lawyer, I would not hire her.
Good afternoon, everyone. You can be seated.
Good afternoon.
Thank you all for coming back this afternoon. As I indicated this morning, we had a legal issue. So if you want to have a doll, like a Mark Lemieux doll that you want to use to kind of stab at for being late, you can blame everything on me, on nobody else. Sometimes things take longer than expected, but we are ready to proceed at this point in time. So thank you very much for your patience, for coming back for the afternoon. We really do appreciate it. Thank you on behalf of everyone here. We're back on the record with State of New Jersey versus Paul Caneiro. It's indictment 19-02-0283. And have the appearances of counsel for the record.
Good afternoon, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good afternoon, Judge Chris Decker for the state.
Good afternoon, Your Honor. Monica Castellan on behalf of Mr. Paul Caneiro, who's present.
Good afternoon, Andy.
Okay, good afternoon, everyone. Good afternoon, Mr. Caneiro. We'll continue on with the testimony of Caitlin Caneiro. If she can be brought back up, please. Just watch your step, please, if you don't mind. I want to remind you, you're still under oath from yesterday, okay? We can continue on with the direct examination. Go ahead.
Thank you. Good afternoon, Katie.
Good afternoon.
So just a couple more topics I wanted to cover. One of them I wanted to circle back to was I think you testified yesterday about the Porsche Macan.
Yeah.
And I think you mentioned it was a loaner vehicle.
Yes.
Approximately how long did your dad have the loaner vehicle for?
I'd say less than a week.
And why did he have a loaner vehicle?
His car was in the shop. I don't remember why.
And with respect to, we also heard a little bit about soundproofing in your house through some testimony. Was the master bedroom of the house soundproofed?
Yes.
And what about the basement?
Yes.
Okay. And to your knowledge, who did the construction of who did the construction of the remodeling and including the soundproofing?
It was Corey's best friend, Tom Z.
And as the construction and the soundproofing was happening, was Corey ever there at any point?
Yeah, he would stop over and him and Tom Z would go get lunch together occasionally.
Now, We've also heard testimony about a little bit about a backpack. Did your dad have a backpack?
Yeah.
And is that something that, did you see him carry it around?
Yeah, he carried it everywhere. It was almost like an extension of his wallet. Like everywhere he went, the backpack went.
And for how long would you say that your knowledge your dad had the backpack?
I don't know exactly, but at least since I've been in high school.
So
That time, around 10 years.
10 years. And just a couple questions about your dad. Can you tell us a little bit about your dad as a dad? Was he a good dad or?
Yeah.
Objection.
It's irrelevant. It's irrelevant. Sustained.
Okay. How about your dad as a brother? How was his relationship with Keith?
It was very good. They were very close. They did everything together.
And what about your dad as an uncle? How was he with Jesse and Sophia?
I mean, he treated them like he treated me and Marissa like his own kids, and he would
We
drop
did this
everything
already.
for us. He'd always be there. He was very supportive. It was just good to have around.
What about specifically about Jesse? What, if anything, can you tell us about their bond?
They had a great relationship. They had a lot of things in common. Jesse loved history. My dad loves history. So they would do a lot of things like that. When Jesse was learning how to swim at the Sultan Club, he asked my dad, who I tagged along with, and we watched his like little race when he learned to swim. And then one time, I think Jesse was in preschool, he was able to bring like a special friend to show off to his class, and he invited my dad.
Did your dad and Jesse ever do things together, like lunch or anything like
Yeah,
that?
they did a lot together. When Jesse was bored at home, he would call my dad to hang out. And either Jesse would get dropped off or my dad would go there. But they did a lot together.
That's all I have. Thank you.
Cross.
Ms. Caneiro, it sounds like the children, Jesse and Sophia, would have trusted your dad, right?
Yes.
Now, do you recall yesterday, there was some testimony where you had sent your Aunt Jen a text message on November 20th in the morning of 2018?
Yes.
And I think you said you sent the text message at about 10:26 a.m.?
Yes.
And your phone number ended in, it was 7924, is that correct?
Yes.
I'm just going to approach you with D154, which you've seen yesterday. And I believe that was what was shown to you yesterday, is that right?
Yes.
Okay. Now, this message, it's actually on the back page of it. The green bubble here where it says, the text message to her, where are you?
Yes.
Does it show as being read on here?
No.
Just delivered, right?
Just delivered.
Okay. And then I think you said you looked at it later and eventually you saw that it was read.
Yes.
Now, does this appear to be a group text message? Let me ask you this. Do you see these numbers here right before it? The first number?
Yes.
Is that says owner? Is that your number?
Yes.
And that ends in the 7924 number. Is that correct?
Yes.
And then you have Aunt Jen's number here.
Yes.
And then this 848 number. Do you see that number?
Mhm.
Do you recognize that?
No.
Is that a number associated with EcoStar?
I have no idea.
You don't know. It was in your group text message though, right?
There was no group text message with my aunt.
Okay, well then what is this?
I don't know.
Objection?
We talked about.
Oral.
Okay, let me show you. I'll show you something else.
Ms. Caneiro, did you have another phone number at the time or another number that was associated with your phone?
Whenever I traveled to Greece, I had a different SIM card.
Did you have a different phone number?
It was a different SIM card, so yes.
So yes, a different phone number.
Yes.
Yes, okay. And that other phone number, was that 732-268? No?
No, it was a Greek number.
Okay. I'm gonna show you what has been marked and I'll show council as S504. First page of the extraction report. First page of the extraction report. May I approach?
You can.
Okay, I'm going to show you what has been marked as S504. This is the first page of your extraction report from your cell phone. And let me just ask you, you recall that your cell phone was extracted back in 2018, right?
Yes.
Okay. I'm just going to show you you recognize this number here. This 7924 number. Do you recognize that?
Mm-hmm.
Okay. Is that your number?
Yes.
And that's the number you texted Aunt Jen from, right?
Yes.
And then this number here that ends in 8977. Wait a second, I'm sorry. It's actually 9357 right there. Do you see that?
Yes.
Okay. That's on the extraction report. Do you recognize that phone number?
No.
You don't recognize that? Okay. I'm showing coaching with S505. If we could take a look, I'm going to show you first D154. This is your text message, right, to your Aunt Jen on 11/20/18?
Mm-hmm.
Okay. And I'm going
You
to
have
show
to
you.
say yes or no.
Yes.
I'm going to show you what's been marked as S505. Do you recognize that same text message on here?
Yes.
Okay. And does that appear to be part of a group text message?
No.
It doesn't?
It's not a group text. It's a conversation between me and my aunt
Okay.
on the previous day.
But do you see the numbers up here where it says Aunt Jen and then it has the 848 number and the other number that is marked 357? Do you see that?
I see it, yes.
Okay. Does that appear to be a group text message?
I don't know. I don't see any other text messages. This is, if you look at my phone, it is a conversation between me and my Aunt Jen.
Ms. Caneiro, I'm gonna ask you a couple of questions just to clarify some of the cars that you guys owned. So you indicated your dad owned or drove a white Porsche Macan, is that right?
Yeah, this was a turbo.
Okay, and I think you said his car was actually in for service, so he had a loaner car.
Mhm.
And the loaner car that he had on 11/20/18, that was also a white Porsche Macan, is that correct?
Yes.
Okay, and it had like the black strip on the bottom doors.
I'm sorry?
I don't remember.
You don't remember? Your mom's car, the car that she drove was a Porsche Cayenne, is that correct?
Yes.
Is that the car she routinely drove?
Yes.
And that's the car your dad pulled out of the garage, is that right?
Yes.
Now, did that car have a remote garage door opener in it?
Yes.
It did, okay.
You had an alarm system in your house, isn't that correct?
Yes.
And did you have multiple cameras in your house?
Yes.
So you had an alarm system. Did you also have a DVR system that was separate?
I don't know how it works, but
Okay, so you had an alarm though system that was hooked up to your house?
it was, but it never works, so.
Okay. Certain doors like would beep when you were
Yes.
coming in and out, and then some doors didn't beep, right?
Yes.
When you were coming in and out. All right, so you had that, and then you had some cameras inside your house, is that right?
I know that now. I didn't know that back then.
You also had cameras outside your
Outside,
house, is that
yeah.
correct? And then you had like a DVR box that was located in the garage, right?
Yes.
All right, so I would imagine at night you kept your doors locked, is that right?
Yes.
Now, the doors that would beep when you would go in and out,
That would be the front door, is that correct?
Front door, yes.
And then the garage doors?
Both of them, yes.
and was there another one?
Yeah, the back door in the laundry room.
Back door. Now, the French doors and the sliders, they would not beep, right,
No.
if you're coming in and out. And where were those doors located?
The slider doors were in my kitchen and the French doors were in the dining room.
Okay, and did they lead right out to the backyard?
To my deck,
To the deck?
which was in the backyard, yes.
Now, you indicated that your dad's room was the guest room, is that correct? And was that room, if you go up the stairs, would it be all the way to the left?
Yes.
And then next to his room was your room, right?
Yes.
And then next to your room was your sister's room?
Yes.
Marissa's room? And then was there a bathroom after that?
Yep.
And then the master bedroom, right?
Yes.
Okay. And the master bedroom, that was the side that was closest to the fire, right?
One part of the master bedroom. I mean, it wasn't the bedroom, it was the closet and the bathroom.
So it like shared a wall with essentially where the fire was?
The fire started in the basement and it went up the back of my house, which was the master bathroom and the master bedroom, not the bedroom, master closet, not the bedroom.
Okay, so the master bedroom closet was where
Yes.
the fire started, right?
No, it ended in the closet.
Okay, but it was on that side of the house, you
Yes.
understand what I'm saying?
Yes.
Okay.
But the
Your
bedroom
mom-
went all the way across.
Understood. It wasn't closest to your dad's room, right?
No, it was closest to the master and my sister's side of the house.
Got it. Now, your mom, you guys had some Australian sheepdogs, is that right?
Yes.
2 of them?
Yes.
Okay, and I think you indicated, or you may have been indicated that they were with your mom in bed?
That's where they slept. And
Did you ever hear them barking in the night?
No.
Now, on 11/19 of 2018, you worked all day,
yes.
and then you got home at, I think you said at about 6:15, correct me if I'm wrong.
I don't remember the exact time, but 5, 6, yes.
Go to bed that night?
Yes.
Your sister and your mom went to bed before you, is that correct?
Yes.
And you went up to bed at about 11:30?
Yes.
Now, when you came home, your dad was already up in his bedroom in the guest room, is that correct?
Yes.
Okay, and you did not see him the rest of the night, is that right? I know you indicated, I think, on direct examination that he was sleeping.
Yes.
Okay. You didn't see him though, so you can't say what he was doing, is that correct?
No, I didn't go in his room.
Now, obviously, you wouldn't be able to see anything or hear anything that he may or may not have done when you were sleeping, is that correct?
What? Sorry.
You were not able to see your dad, anything he may have been doing in the middle of the night while you were sleeping, is that correct? And he was the first person you saw the next morning, is that right?
Yes.
He was the one that woke you up?
Yes.
Yeah, so obviously he was already awake before you were awake, is that correct?
I took sleeping pills the night before, so I did not hear the fire alarm.
But he was awake prior to you being awake, is that correct?
Yes, I was the last one awake.
Okay. Now, you mentioned on direct examination that your dad kept some of his guns in the unfinished part of the basement, is that right?
Yes.
Is there like a metal locker down there?
I don't know what it looked like. Like, I know the area, like I would be able to recognize as my basement, but I don't know exactly.
Okay, but his guns were kept, you said, in the basement?
In a locked area, I guess.
And also there was a safe in the garage too, is that
Yes.
right? Okay. But that wasn't the only place that your dad had his guns, was it?
To my knowledge, it was.
You weren't aware of a Sig Sauer gun that was located in the guest bedroom with a laser light in it?
I don't know what a 6 hour is.
Do you know what a laser light is?
It's a laser, that's a light.
Do you know what it is or no?
No.
Okay. You don't know what it's used for?
No.
Now, your dad was good with IT and tech related things, is that correct?
This is what he did for a living, so yes.
And he installed the cameras in your home?
Installed, I wasn't there for it. I have no idea.
Did he set the cameras up in your home?
He used the cameras.
Okay, and would he maintain the cameras?
Yes.
He would be the one to handle anything camera related?
Yes.
Okay. Do you know that he also installed, and you may know because you were sitting here, Dr. Gold's cameras?
I know that now.
You know that now, okay. If anyone in the home would know where the DVR was located, the box, it would be your dad, right?
We all knew.
Including your dad, right?
Yes.
He was the one that maintained the cameras, correct?
Yes.
Do you remember an officer approaching you and your father on the morning of 11/20 and asking your dad where the DVR system was located?
I don't remember, but I saw it here. I was here.
It's not here.
Yeah.
You don't remember that, but you remember your dad saying, "Oh fuck, I hurt my hand."
Just yes.
To be clear, okay. Let's play, if we could, permission to play S78, which is the DVR of that portion of the testimony. I'm just gonna pause it.
I wish she'd stand next to a mic.
Okay, okay. Ms. Caneiro, I'm gonna ask you just to watch this, and I might pause it and ask you a couple of questions. You can just have the court volume up, please. Pause it, please. Do you recognize the individuals on the screen or any of them?
Yeah, this is my dad and my mom.
Okay, and whose car is that in the back?
My mom's.
The white Porsche Cayenne?
Yes.
Okay.
It's your house? Yes. Where is that?
It's me, not my mom.
Oh, all the DVD stuff for the cameras and everything in the house? It's in the garage. In the garage? Yeah. Where in the garage?
I just want to be clear. Did you see when the officer asked you where all of the cameras were located? Did you see that part?
Yes.
And your dad looked at you and you said the garage. Did you see that part?
Yes.
Okay, go ahead.
You walk in the garage and it's all the way up top to the left.
And then the officer asked specifically where in the garage, correct?
Yes.
And your dad looked to you and said,
He was talking to both of us.
Okay, my question was your dad looked at you and said, is that correct?
Yes.
Okay, and then you told the officer specifically where the cameras were located, is that right?
Yes.
Do you have it running right now?
I've been having problems with stuff in the garage.
You've been having problems with stuff in the garage?
Yeah.
Okay.
I haven't taken it open actually, but all the companies.
Okay.
Now, did you hear your dad at that point say that he had been having problems with stuff in the garage
Yes.
and that he had a ticket open with one of the companies?
Yes.
You had no idea what that meant, is that correct?
No.
Yes or no?
I said no.
It's not correct.
No, I don't. I had no idea.
You didn't know what he was talking
No.
about? Because according to you, prior to you going to sleep that night, the cameras appeared to be in working order, is that correct?
I didn't check, but I would assume so.
Okay. And do you recall saying that in your statement that you gave to the police?
Yes.
That the cameras appear to be in working order prior to you going to sleep?
Yes.
Can I just see D1, 425 to 430, please? D1, 425 to 430.
No, thank you. No eye contact.
I'm approaching with what has been marked as D425 first. You were shown this picture the other day, is that right?
Yes.
Okay, and that's a picture of your mom, your dad, and Jesse and Sophia, is that right?
Yes.
And how old are they here?
I'll say 4, 2.
Two and 4? I'm going to show you what's been marked as D426. Do you recognize that?
Yes.
And who is that?
Jesse and my dad.
And how old is Jesse there?
3.
3. Showing you what's been marked as D1 427. Is that your dad and Sophia?
Yes.
How old is Sophia about there?
2.
Showing you what has been marked as D428. Do you recognize that one?
Yes.
That's your dad and Sophia, right?
Yes.
And how old is she there about?
3.
3. Showing you what's been marked as D429. Do you recognize that?
Yes.
And what is that?
Jesse and my dad.
Okay, and about how old is he there?
5.
5. Okay, and then I'm showing you finally what's been marked as D430. Do you recognize that?
Yeah.
And is that Jesse and your dad?
Yes.
And about how old is Jesse there?
5.
When Jesse passed away, he was 11, right?
Yes.
And Sophia was 8?
Yes.
Okay. So of the photos that you chose to sample for your dad's special bond with the kids, they were older photos, is that correct?
I mean, yes, because that's all we have.
Older
All I
photos?
have. Yeah.
You indicated that your dad and your Uncle Keith were close, is that correct?
Yes.
Are you aware that they were so close that your dad was actually the trustee for your Uncle Keith's life insurance trust?
Yes.
You're aware of that?
I'm aware of that.
You were aware that they spoke daily, I believe you said too, right?
Yes.
Okay. Were you aware that your Uncle Keith actually called your house line on the night of November 19th of 2020?
I was at work, so no.
So you were not aware of that? Were you aware that your Uncle Keith actually spoke to your mom once that night?
I know now, but no, I was not aware that day.
When your dad told you about the 4 text messages that Uncle Keith sent him in the middle of the night, he didn't tell you about those 2 phone calls?
No,
And by the way, the 4 text messages, when did your dad tell you about that?
that morning,
About when?
9:30 or 10.
Your mom, she did not work outside the home, is that correct?
No.
Do you recall her ever working outside of the home since you were born?
Yes.
You do, okay. How long did she not work outside of the home for?
Probably since I was in first grade until after this.
Okay. And your dad was the one who paid the bills, is that right?
I have no idea.
Okay, you're not sure?
No.
Just speaking of bills, you guys had, there were 2 Porsches that we heard about that your parents each drove, is that right? And then what kind of car did you drive?
I drove a Porsche Carrera S,
Okay. And how about your sister?
Jeep Wrangler.
Okay. Did any of your family members drive an Audi?
No.
No?
Oh, wait, Keith
Keith
had an Audi at one point. I don't remember if he had it then,
In
but
2018.
okay, no.
Did your dad pay for Keith's Audi?
I have no idea.
Now, you testified on direct examination that when you were about halfway down the stairs, you remember a loud bang, right? And yes, and then your dad saying, quote, "Oh fuck." Do I have that quote right? Or "Oh fuck my hand." Is that right? Okay. When in the last 7.5 years did you remember that little tidbit?
The whole time.
Because you didn't seem to remember it when you gave your statement back on the date that it actually happened. Right, it's not in your statement?
It's not in my statement, no, because I was asking to leave and they kept telling me that my cousins were okay and they would take me after my statement, so I wanted to get through it.
But 7.5 later, you come in here and you remember it today.
Why would I forget that?
Kind of like 7.5 years later, you decided to check the status of your Aunt Jen's text message, right?
Yes.
What prompted you to do that, by the way?
Because we were talking about her?
You hadn't checked it from the time you sent it though, correct?
Not since that day.
Okay. And then I think you said you checked it a couple of days ago, right?
Yes.
So a couple of days before you were coming in to testify on behalf of your dad, right?
Yes.
With regard to your dad's hand injury, you didn't actually see him get the injury, is that correct?
I didn't see him hit his hand, no. I heard
You weren't
it.
even sure which hand it was, is that right?
No.
Just the last couple of questions, Ms. Caneiro. You were obviously close with your Uncle Keith, is that right? Yes. And your Aunt Jen, and your cousins, Jesse and Sophia.
Yes.
And you're close with your dad, is that right?
Yes.
You guys have always had a close relationship,
Yes.
and you've maintained that relationship throughout the years, is that correct?
Yes.
And you're here today testifying on your dad's behalf, is that correct?
Yes.
You don't want to see anything bad happen to him, right?
What's worse?
You don't want to lose him too, is that correct?
He's already been gone. There'd be nothing that would change.
Any redirect?
Now she's going to say that this opened the door and she should be able to ask some of these questions, but we're never going to hear it. But I'm pretty sure that's what she's about. We will see. Actually, we won't see because it's. Well, she's tired. She's pretty calm on the stand. She's yawning. That's the second yawn I saw. You will see these sidebars someday if Paul is convicted and there's an appeal and the sidebar is part of the transcript on appeal and you get the appeal transcript, you will see what the sidebar was. And I don't know whether in New Jersey the entire transcript goes up on appeal or whether each side identifies those parts of the transcript that are pertinent to the issues they're raising on appeal. It's done both ways. And if the whole transcript goes up, then for certain you'll be able to see the sidebars, unless there's something privileged in them, and I don't think that's what's happening here. And otherwise, you'll see it only if it's relevant to an appeal issue. Thank you, Megan Cogmail. Welcome to Legal Scholar. Thanks very much. I appreciate your becoming a member. Very helpful, very excited about it. I hope you find it enjoyable, entertaining, interesting, and worthwhile. And I'll do my best to make it so. Yeah, Tiger Lily says she absolutely insulted the judge. Yeah, and it was interesting. I mentioned that this morning. A lot of those were sidebars after she was, an objection was sustained and she didn't like the answer. So then she would go back to re-argue it. They call it chutzpah, and she certainly has it. Yeah, Linda 460, I agree. Her mother didn't work, but she didn't know who paid the bills. I agree. That was a little peculiar as an answer. Yeah, it does look like it. My emoji does look like it's on the screen, doesn't it? My little avatar there. It was that way yesterday, because I remember seeing it yesterday also. Amber does those. She's really a genius. Lauren B8B1D, the entire transcript gets submitted in any appeal. Is that true in New Jersey? Because it's not true everywhere. But are you telling me that in New Jersey that's what happens? Okay. Plain Jane says the same thing. The whole transcript goes up. She's a criminal defense paralegal. Thank you. That's what it was when I, prosecuted, but I wasn't sure if it was still true. So then any of the sidebars, unless there's something privileged that is really for the judge's eyes only, if Paul is appealed, if Paul is convicted, he will appeal, and then you can see the entire list of sidebars, and there certainly were a lot of them. What door was opened? Centers, I don't know what you're referring to. I know she talked about the sliders in the kitchen and the other doors, the French doors in the dining room, and the 2 doors or 3 doors into the garage, into the house. Oh, well, thank you, McGonic Mail. That's very kind of you to say that. Oh, Mike Gonco. Gonco. I had McGonico. I had an extra vowel in there, didn't I? So it's M. Gonco. Okay, thank you. Yeah, she does a great job. She's got one of me eating pizza for Pizza Day yesterday. And she had an elegant one for New Year's Day, with very elegant. I think it was pearls and a glass of, I'm going to say Prosecco, because I like that much better than champagne. Oh, sorry. You didn't mean a physical door. You meant my comment that the defense would argue that the state opened a door. It's when the state asked questions about the text And the information was the first part of it with regard to the text that she had testified about. That's the door that I think the defense is now opening, allows them to go into the text messages. I'm doing my usual recap at 5:30, not 5. But I am doing it. We're a little later because I need to organize better, and we're going to be showing clips of today, so it will take a little longer to do. The video from the scene showed the daughter lied she knew where the VCR was in the garage. Did she say she didn't? I thought she said everybody knew where the DVR was. The question was, does Paul know? And I thought her answer was everybody did. Did I mishear? Yeah, Just Me says the guess is since the prosecutor asked about the message to Jennifer, the defense thinks it should be able to talk about what was shot down this morning. Yep, that's what I just said. Exactly. Is the woman with the scarves there today or no? And there's the brother-in-law. There he is. And Jennifer's sister, Jennifer's mother. The woman who's always next to Jennifer's mother. And then maybe the woman with her head down is the one who usually has the scarf on. It looks like I can see the sort of top of the scarf.
Whenever you're ready.
A few follow-up questions. Starting with the text message with your Aunt Jennifer, do you still have that text message in your phone?
Yes.
As you sit here today?
Yes.
And earlier today, did you have an opportunity to show it to the prosecutors?
Yes.
Okay. And from what you can tell on your phone, is it a group message or not?
It's not a group message, and if it was, you wouldn't be able to see that it's red. Group messages don't work like that.
Obviously, you didn't have access to your extraction report, correct?
No.
Now, you were also asked on cross-examination about the cameras in your house.
Mm-hmm. Yes.
And in your statement to the police, I think the prosecutor asked you, to the best of your knowledge, or they were working at the time.
Yes.
Okay. Did you specifically check your cameras the night before?
I said, no, I didn't. I wasn't one to check my cameras ever.
Okay.
Something I did.
So when you told the police that your cameras were working, what did you mean by that exactly?
I mean, I wouldn't see why they wouldn't be working.
Okay. But was there, returning back to your testimony about the 18th and what was happening earlier that day, what was?
We were having issues with our Wi-Fi that weekend leading up. And I don't know if it was resolved. I went to work the next day. I wasn't there all day.
And the prosecutor also talked to you a little bit about, I guess, whether you ever heard your dogs barking at night.
Yeah.
At the time that, and during the overnight hours, where were the dogs?
In my mom's room.
Okay. And did you mention earlier, is that the master bedroom?
That's the master, yes.
And is the master proof to some extent soundproof?
Yes.
And the last thing I want to ask you about is the prosecutor asked you about your statement and things that you didn't
Yes.
maybe mention during your statement. And I think you started to get into it, but what were the circumstances that you were giving, under which you were giving that statement?
I kept asking about my cousins, and I was being told that once I gave my formal statement, I would be brought to them at wherever they were located, whether it was a local hospital somewhere. And I had no idea what was going on. I had no idea anything about that day. And my statement was a basic statement. I was trying to get out of there. I wasn't sitting there going, no one was telling me anything. They just asked me what happened that day. And I briefly said what happened that day.
Did you know at the time what was important or not important to mention?
I had no idea what was going on. No one was giving me answers. I kept asking to leave. I kept asking to find people. I kept asking what was going on, and they would just move past and say, like, we'll answer everything when you're done.
That's all, thank you.
Recross.
Very quickly, Keith Caneiro, the DVR system that your cameras were hooked up to, that was actually hardwired, and Wi-Fi would not have affected it. Is that correct?
I have no idea.
You don't know, okay. And then just in terms of you being at the police department, and you indicated they wouldn't let you leave, right?
Yes.
It's fair to say there was a fire at your house, right? At that point, there had been a
Yes.
fire, and then there was a fire at your Uncle Keith's house, right?
Yes.
It was important for them to figure out how these fires might have started and who could have started them. Is that correct?
Yes.
And your safety was also important because at that point,
My safety. I was having an asthma attack, and they wouldn't let me get my inhaler.
Can you wait for her to finish
Sure.
asking the question before you start responding? Go
Thank you,
ahead.
Judge. I'll ask it a little differently. At that point, you guys didn't know who, if anyone, could have been targeting the two families. Is that correct?
Sure.
Thank you. I have nothing further.
You can step down. Defense, call the next witness.
We're not saying defense rest. Well, they are allowed to sit in the courtroom. They haven't been sequestered under an order to stay out. That's interesting. Usually, once the side that's not calling witness asks the witnesses of the other side to not be allowed in.
To tell the truth, the whole truth, and nothing but the truth, so help you God. Okay. Once you're seated and comfortable, can you state your full name for the record and spell your last name, please?
Marissa Caneiro, Caneiro.
Okay. Ms. Caneiro, I just asked you to speak up. You probably heard me say that a couple times. Just speak up so juror number 15 and 16 can hear you. Go ahead, counsel.
Good morning, Marissa. Good afternoon, Marissa. Can you just introduce yourself briefly to the jury?
I'm Marissa, and I'm Paul's youngest daughter.
And we heard a lot yesterday from your sister Katie about what transpired on November 20th of 2018. So I just want to focus you in on one specific thing that happened. At a certain point, were you at the police station with your family?
Yes.
And during that time, were you taken downstairs to a conference room?
Yes.
And while you were in that conference room with your dad, did you learn any information about what was happening with your family?
When we were alone, me and him.
Yeah, here, I'll back up. At some point, are you in the conference room with your entire family?
Yes.
Okay. And thereafter, were certain members of your family taken out, and were you left alone with your dad in the conference room?
Yes. My mom and sister were taken out of the room, and then it was just me and my dad in there.
And when it was just you and your dad, was there a point in time where you learned information about your family?
Yes. A police officer came in, and he told me and my dad that.
I'm sorry.
Just say.
Did you learn what happened, just without saying what was said, did you learn what had happened with your Uncle Keith and Jennifer and their family?
Yes.
And did you learn that they were deceased?
Yes.
And can you just describe that moment that you learned that and what your reaction was and what your dad's reaction was?
Relevance.
You can answer as it relates to your dad.
When they told us that everyone died, my dad was really upset and crying. He fell to the floor, and I was sitting across from him at that point. So I got up and I was on the floor with him, just holding him. He was crying a lot, and my shoulder was wet. And then eventually they told me I had to leave the room as well. So I don't know what else happened.
When you were in the room with your dad and he was upset and crying on your shoulder, did you say he fell?
Yeah, he was sitting on the chair and then he like fell to his knees. So I went over there and I was just holding him up.
And about how long were you on the ground with your dad before you were taken out of the room during this time?
Maybe like 3 to 5 minutes.
That's all I have.
Ross?
Just a question. When you were in the police department, ma'am, you were allowed to keep your cell phone on you, right?
Yes.
And all of your family members were allowed to keep their cell phones, is that correct?
Yes.
Okay. And then eventually you ended up giving a statement, is that right?
Yes.
Okay, and then you left that night, correct?
Yes.
I have nothing further.
Can I ask a follow-up?
Sure.
Did you have cell phone service when you were?
No.
You can step down, thank you.
The defense rests, please. The defense rests.
Call the next witness.
Can we approach?
Again. Instead of the defense rests, her 3 words are, can we approach? So the state on cross asked essentially, why didn't Katie tell the police in her initial statement that, her father had said, oh, fuck my hand, or looked at the text, and she said all she wanted to do was get out of there because she was worried about
Research.
family. Are we taking a recess? Is that what he said? All right, we're doing a recess. Maybe I misheard.
All right, I'll be back home in 5 minutes.
He's leaving for 5 minutes. So it's either a bathroom break or he wants to check some case law quickly. And she said, she wanted to get out of there. And that to me rings true in terms of what the police would have told her. They're going to want to ask their questions and not give any information. It also actually rings true to me that there's a fire at the house. She at some point has some information that was a fire at her uncle's house. She wants to get out and find out what's going on, and that she'd want to get that statement done as quickly as possible. Both those things ring true to me, as does, in fact, the fact that she might not have told everything that occurred or even thought about telling everything that occurred. So that part of it, I don't think, for me, the state didn't make any points by saying she didn't tell anything then. Now, and then they tried to interview her again and she wouldn't be interviewed, so you don't get the chance to follow up and get more information. I suppose the prosecutor could have asked her that. Did the law enforcement try to come back and interview you again? But she would have just said what she said what we heard her say that was struck from the record, and that is, I wouldn't, they rushed me. I had asthma. They wouldn't let me even get my, what is it, an inhalator? What do they call the thing that they use? They just took her outside to breathe, and she didn't want too much. She didn't want to talk to them anymore. And I think that would probably have rung true with the jury also, or at least some jurors. Then Christine says, so the defense witnesses to get to sit through the trial before they testify. I'm surprised that they're there. And I don't know a place where the opposing side can't request that all the witnesses for the other side not sit through and hear the testimony. So I'm surprised either the prosecutor didn't ask. Well, it's not an either. There, I've got three alternatives. Maybe the prosecutor didn't ask, which would surprise me, or New Jersey doesn't have the rule, which would surprise me even more, or because they are relatives of the accused, there might be a special rule for them, which also surprises me. So I don't have an answer. I don't think they should have been there, and I don't know why they were. Maybe our person in the chat who knows New Jersey criminal law, who told us that the whole transcript goes up, might know the answer to this. And if so, please put it in the chat. Okay. All right. J.M. Dickerson wants to know if I can keep you all informed if the judge writes a complaint against Monica. If it's a complaint to the bar, those things are typically confidential. And unless there's a decision, that she's being disciplined, you never know that the complaint was filed. At least that's my understanding everywhere. So I wouldn't know. So. Inhaler, thank you. Thank you, Stella Bella. Thank you, Christine. So I'm really bad with names, but usually words I remember. But, they made me get up even earlier today. I suppose the defense could say that keeping the family members out may tell the jury they don't stand by him. But after they testify, they can sit in the courtroom. And the judge, if the defense requested it, might have been willing to give an instruction to the jury that witnesses are not permitted to sit in court until after they testify. And that would have solved that issue. And the jurors may not know who the family members are, so it may not even come up. And once they testify for the defense, the jury will certainly know that they support their father or husband. So it's only in the interim before they testify. And if they're not going to testify, they can sit there and support. So I don't know that would be a good reason for having a rule that says they can't be there. But it might be a throwback. I don't know. There used to be a time when you could keep the family members of the victim out of the courtroom on the theory that it would prejudice the defendant to see that the family members were in court and upset. And that no longer is the case, thankfully. So Christine says, perhaps it was just strategic so they could hear the testimony. Of course, the defense would want them there because then you can tailor your testimony to what you've heard. That's true, but that's exactly the reason why the prosecutor would not want witnesses for the defense in the courtroom, and vice versa, that the defense would not want witnesses for the prosecutor to be sitting in the courtroom during the testimony. The defense attorney is a public defender. Both of them are. And Sandra Baker says the attitude of the defense attorney and the daughter is shocking. I said this yesterday. I didn't find her attitude all that shocking. I thought it was okay. And I can understand somebody, the family member of the defendant, being antagonistic to the prosecutor. And I think the jury would understand that. And most of the time, she was pretty neutral about it. When the prosecutor gave her the chance, then she went off on how she was treated at police headquarters. But I didn't find it. But I said to you, I've got I suppose, because I see it in the chat, a much higher tolerance for that sort of thing than a lot of other people do. So you may be closer to how the jury is seeing it all than I. The complaints in New Jersey, Geneva Rogers, are public record? Wow. They are not in a lot of places, just the decision. That's why we don't know if Daniel Rashman, what's happening with his case in the Donna Adelson, Charlie Adelson, Carfunkel. That's probably too kerfuffle. That's probably too light a description of it. We know that complaints were filed because the judge was pretty clear in the opinion he wrote that he thought there was a violation, and you would expect he would have filed. And we know that at least one person, the person who's got the channel, Patty's Playhouse, filed a complaint. But we know nothing because in Florida, unless there's a finding against the lawyer, it's not public. And I would have guessed that was the rule everywhere. So I'm surprised in New Jersey you can find it. Well, if that's true, then anybody can find it. You just have to go on the on the docket of the disciplinary board. Am I admitted to practice law in New Jersey? Yes. Okay. Okay, in Idaho and Arizona, the Daybell family sat in court. Did all of them testify? I mean, if you're not going to testify, you can sit, there's no problem. You can sit in court. So, and I don't know I didn't watch the Daybell trial. I saw snippets of it, but I mostly didn't watch the trial. So I don't know. And you don't know, the prosecutor, for reasons I don't understand, might have said it's okay or not raise the issue. He looks tired. He looks like he's going to say something he doesn't want to say.
Ms. Messelin, what is your pleasure?
Judge, at this time, the defense can rest.
Did she say the defense rests?
Okay. Mr. Caneiro, can you stand up for me?
Now we're going to do the,
Okay. Mr.
You're
Caneiro,
waving.
There's a model charge that can be given, but it's truly your decision on whether that I give this or not. It's titled Defendant's Election Not to Testify. It says, as you know, defendant elected not to testify at trial. It is his constitutional right to remain silent. You must not consider for any purpose or in any manner in arriving at your verdict the fact that the defendant did not testify.
Good thing he didn't look up.
That fact should not enter into your deliberations or discussions in any manner at any time. Defendant is entitled to have the jury consider all evidence presented at trial. He is presumed innocent, whether or not he chooses to testify. Have you had the opportunity to speak to your attorney as it relates to this charge?
I have.
Okay. And what is your position? Do you want it read or not read?
Read to the jury.
You want it read?
Yes, please.
Okay. And that you've had enough time to speak to your attorney about that?
Yes,
All right. And then after full consultation, you want me to read this charge?
please.
I will read it. Okay. Thank you. Thank you, sir.
When did they
All right,
ask
ladies
him
and gentlemen. So what our plan would be, is there
about
going to
the
be any rebuttal?
consequences?
No, Judge.
Okay. So with
No
that being
rebuttal.
said, what I will do is I'll bring the jury back out. The defense can rest. The state will then indicate that there will be no rebuttal. At that point in time,
Say, not
we have
indicate.
already started with the moving of evidence. We'll continue on in that process. We'll go over the jury charge for the last time, and then we'll be ready for summations. Not today.
I'm just
But
going to say he's not
can we
going to
bring
do
the
it
jurors out,
today.
please?
No question.
Plenty of time.
If the judge had looked up and seen her talking to her client while he was reading that instruction to Paul, we would have had another eruption.
Yes, please, if you don't mind. Forgot to stand up.
There you go. I got you.
No, I didn't get the scarf in Italy. I ordered it online. It's got a, I like it because it's got a
At this point in time,
the necklace part of it.
what
So
is the state's preference, or the defense's preference with moving forward? Any other witnesses?
No further witnesses, Judge, we rest at this point in time.
All right, so the defense rests. Will there be any rebuttal from the state?
Judge, there will not be any rebuttal.
Okay. So ladies and gentlemen, here's where we are. We're at a time where all the testimony has been concluded. One area that still is outstanding that's going to be done now outside of your presence, you will not have to sit here for it. But I decide, remember all the exhibits that you've heard about through the course of the trial? The court makes a decision on which actual exhibits you have in the jury deliberation room at the time that you start your deliberations. While you may not have every single exhibit that was mentioned, you would be able to consider the testimony of any and all exhibits. It will only be the exhibits that I give you are the ones that you're allowed to physically have in the jury room. So if you're one of the 12 deliberating jurors and you say, Judge forgot to give me exhibit number whatever, I didn't forget. I promise you that. You're going to get what you're going to be allowed to have, but you can always remember the testimony. That's why there's 12 of you that will decide this case, and you can remember whatever you want to remember. So that's number one. Number two, if you recall, what I've said is that at the end of the case, at the end of the summations, I give you the law that you will have to apply to the facts as you find the facts in this particular case. I go over that law with the attorneys on several occasions before it's ever read to you. We've done that a few times. I'm going to do that for the final time this afternoon to make sure that that's also accomplished. So while I'm letting you go, and I know today was not the best for time-wise, I hope that you understand that our plan is we're going to finish that up tonight. Summations will be tomorrow morning. You'll be here tomorrow morning at normal time, which will be 8 o'clock. We'll start at 8:30. Summations will start in reverse order. We start with the defense's summation, then we'll have the state summation, and then we'll move into the actual charge. It is after that, then we get into the deliberations, and we'll pick, if everybody remembers, then we get to see how we pick alternates in this Monmouth County. Pretty high tech. It's very exciting. Can't wait to show it to you. So with that being said, though, that you're done for tonight. You don't discuss this case. Now, just because we're at a point where we're done with all the testimony, do not discuss this case. There's no greater time than right now than a need for you to listen, not to discuss this case at all. You haven't heard the summations. You haven't heard my charge. Only deliberation is done in that jury room with the door shut, and that's for you and you alone when you decide to start your deliberations. So with that being said, don't discuss this case. Don't do any research. I hope you have an excellent night. I'll see you tomorrow morning. Please be safe. Thank you so much.
So they're not going to read any of the charge beforehand? Boy, I think that's the wrong way to do it. I think the jury needs to hear some of the charge before the closings. Not going to happen. Yeah, there were people in the chat who said she was chastened by what happened and was quieter. I think that's probably correct. See, he can talk. I think she's sending him to talk to the prosecutors now. He's going to be the voice of the defense. They don't read a pre-charge in New Jersey. I think that's not the best way to do it. I think you need some information. They need some information, at least on the elements and on a couple of other things before they hear the closings.
Just give me 1 second, please. So we're going to go back to the exhibits. We spent a good amount of time on Friday afternoon going through all of the exhibits.
Remember, they reserved some until they heard the rest of the evidence, testimony.
Have we figured out the photo book for S1 and taking out the photos?
Yes, we were just, the only one was A, I believe, that we hadn't done, just to make sure that we didn't use anything else, but that everything else is complete, and Ms. Schmidt is actually just finishing subsection A.
All right, so the defense, tonight, you can take a look at it, or before we leave today, because it's only A, it's not as many photos as some of the other sections. But the plan is to take out the photos that were not identified. Is that correct?
That is correct, Judge, and that's what we've done thus far with all the other portions.
Okay. I'll give the defense time to take a look at the book, to go over it, make sure that they're in agreement with the photos. If there's any photo that is still at issue, that on whether it was identified or not, I have them all marked in my photo book also. And I'll give everybody, I would address the issue at that point.
Now we're hearing that the complaint themselves is not public, only the ones where they make a finding. That's what I thought.
Okay, great. Yeah, that'd be great. Thank you. So tell me, let's start with B in the photo book then.
Judge, I can just speak to.
We froze. Or I froze. Maybe the rest of you have not. It looks
The only
like
objections I have are with like the autopsy photos.
Okay.
And the only thing, for example, photo number 7 is, I believe, a photo of Keith's hand and stomach area. And then they have on top, like after that 7.1 with like some markings, it's really just a circle, like I believe, or something to that effect. And so forth and so on. So they have 13, which is Keith Caneiro's head, and it displays 5 gunshot wounds. And they have 13.1, which has certain gunshot wounds, I think, circled. And then they have 13.2, which has more gunshot wounds circled or something to that effect. I don't have it in front of me. I'm just working off of my notes. But they do that for photo number 14, and then they have 14.1 and 14.2. Photo number 15, and then they have 15.1, and they have photo number 16, and they have 16.1 and 16.2. Those are 3 gunshots, including like a gash-shaped gunshot wound on the top of the head. So there's 3 of the same photo. It's just that there's like a circle around something. My position, Judge, well, I'll just keep going. Then there's 17, and then there's 17.1, and then there's 23, and then 23.1. 26 and 26.1.
17 is just the bullet fragments from the brain.
Yes, there's it's a projectile from the brain, but there's, I believe, like there's like blood and brain matter.
Okay.
and then 25 is Sophia, and 25.1. So my position, Judge, would just be that it's essentially cumulative to have the same and prejudicial to have the same autopsy photo numerous times. If the state wanted to use the ones with the markings because they're probative in some way, obviously they can do that, but my position would be that the original should be taken out, since the photo with the marking is obviously, it shows the original plus the marking, or alternatively that they just keep the original and go off of the testimony. Everything, all of the autopsy photos that have markings on them are simply like one wound being circled, I think, with like a pink circle. There's nothing initialed or drawn or explained. I don't, the jurors can see that it's a bullet wound for themselves, and I just think to have repeated photos of the same thing is.
So you're fine with the 0.1s or 0.2s, you're just not, you don't want the duplication of the regular photo with nothing on it and then the circles. Is that what you're saying?
That is what I'm saying. And
Okay.
if there's multiple points, if there's like a 16.1 and 16.2, and it's because 16.1 has like one circle and then 16.2 has two circles, I think that just whatever the final product is of that photo is appropriate, would be my position.
Okay. State's position as it relates to that, if you have the marked up photograph, do you have a position whether it's necessary to have the photos that are not marked up also? And if you do, tell me why.
I'm just trying to evaluate the printer quality, Judge.
Sure, no problem.
There are some differences in the quality of the photos, but, I do see, I certainly would not want to take out anything that was marked up by Dr. Zhang in this regard.
Well, that's why I'm really asking you, do you need the regular photo, considering that I would allow the 0.1 and 0.2 or whatever it is if they're circled in the testimony? Or
Judge, I will defer to the court in that respect, but I do think that we obviously went through a process, a significant process of narrowing down and paring down autopsy photos. Yeah. And ultimately, like, I showed like one picture of Sophia Caneiro, which was a horrible picture, and I left it up for like 0.3 seconds. If they feel the need to look at all the photos, that's part of their determination. I would really ultimately say that I think the photos should stay in as is.
Okay. So 7 or 7, I should start with number 7. And 7 had, on 7, that it had it's not on the list here. Is it a 0.1 and is it more than a 0.1? So the slide 7 shows Keith Caneiro's hand. It also shows part of his stomach area with what was identified as a gunshot wound that went through his hand into his stomach area. Actually, through his stomach area into his hand.
It's actually through his lower back, through his stomach, and then through his
hand and outside.
2 entries, 2 exits.
Yeah. As it relates to that particular photo, I'm going to allow 7 and 7.1 due to the fact that injury in and of itself, the jurors may not remember, and I sat through the testimony also and listened intently of that the crack wound of that injury. So as it relates to 7 and 7.1, I'll allow it. I find the probative value outweighs any prejudicial effect. There's no significant showing of the body here. There's nothing that leads this court to believe that the jurors would be inflamed by this particular photo, and I'm going to allow both 7 and 7.
In case they appeal on the basis of their objection to letting that photo go in. He's making a record.
Was 13. So 13 had, I was testified to by Dr. Zhang, these four holes in Keith's face underneath his right ear is an bullet going in, comes out, goes back in and out. And 13, can I see 13.1 and 13.2, please?
Yes, sir.
If you don't mind, that would make my life easier. Thank you, sir. As it relates to 13, 13.1, and 13.2, the court's going to allow 13.1 and 13.2. That provides a framework for the testimony from Dr. Zhang as to the directionality of the gunshot and how he found it and how it went through the neck and then through the face of Keith Caneiro. And it also talks about, it reminds the jury of the third hole right by the ear as it relates to what he found at that location. So I'm going to allow 13.1 and 13.2. I'm going to exclude 13 as cumulative. I don't think it's necessary for that shot. I feel that that photo doesn't provide any further evidential value for the jurors to make the determination as to that track wound of the bullet. So therefore, I'm going to exclude 13. Again, 13.1 and 13.2 are in evidence. As it relates to 14, there's a 14.1 and 14.2 for the same reasons. I'm going to allow 14.1 and 14.2, which shows Dr. Zhang testifying about where the entrance wound and how it goes in from the side of his head through the upper part of his head. The actual gunshot wound and the directionality of it from 14.1 to 14.2, the circles there. I'm going to allow 14.1 and 14.2, and I'm going to exclude 14 as cumulative. Same for 15.1. Allow 15.1. And for the same reason, 15 will be cumulative. But I find that 15.1 has probative value to explain where it was documented of where the entrance wound was located and circled. I make the same finding for 16. There's a 16.1 and 16.2, I find 16.1 and 16.2 to be evidential. It shows the wound. It orients the jury as to the testimony as it relates to those specific injuries. And for that reason, I will include 16.1, 16.2, and I will exclude 16 as cumulative. Besides, for 17, which includes the projectile from the brain and how it was impacted as it went through Keith's skull, 17.1 circles the projectiles. However, in the circling of the projectiles, it kind of goes through the projectile and in some ways obscures the actual photo. 17 is a clearer shot of these items. So therefore, I don't find them to be cumulative. I find them to each have their own evidential value. And for that reason, I'm going to include slide 17 and 17.1. They're both included in evidence. Okay. Ms. Massalone, was that the only area of the photo book, or was there some other area that we needed to discuss? Mr. Decker, I'm sorry, I stole your book.
That's okay.
Thank you, sir.
Judge, we had no other issue. There was one other photo that we discussed with the state. They're not admitting it, and that's it.
Okay. So the only one that we have left then to discuss at some point is A, after you receive it, correct?
I just reviewed it, Judge. I have no objection.
Okay, so A, as noted, is in. So the final photo book, Mr. Decker, will be where for when summations start tomorrow? Is that the book that you have in front of you?
There's two books.
There's two books.
Yeah.
Okay. So I just want to make sure that final book is in a spot everyone is agreement with it. I don't want it to get lost for any reason. I don't mean that in a negative way. I'm not saying you guys would do that. It's just making sure that we don't want anything going into the jury room except for exactly what we all agree to. Okay. All right. Thank you for that.
Judge, I did previously show the state of photos that we were likely intending to admit. They indicated they didn't have an objection, but I didn't have an opportunity to choose our point ones that we were going to show. So I have them now. It's not too many. I can hand them to the state if they want to take a quick look.
Okay.
See if there's any.
Yeah, we'll have time for that. All right. So I'm going to move things along. I'm going to remind us of what we already have in evidence, and then we can go over, Ms. Wallace, if there's items that I may blow past that we need to talk about, just stop me, okay?
Okay.
All right, so S2 is in evidence. S7 through S12, including the point 1, point 2, point 3, point 4, point 5, and number 12, all in evidence. S17 through S19 in evidence, including proposals A, B, and C. S26 in evidence. S28 in evidence. S29 in evidence, including point 1 through point 10. S30.
I'm sorry, I think the points were in evidence for that.
Oh yeah, you're right, and not the main document. You're right. You're right. Sorry about that. So it's just 29.1 through 29.10 are in evidence, not the overall statements. I apologize. Same with 30. It's just points 1 through 19 that will be in evidence, not the entire statement. Next were the area of S33 through S38. We discussed them. I think we said that 33.1, 34.1, 35.1 were in evidence. However, is there anything else from 33 through through 38 that we needed to have a discussion about, or that was being moved or not moved?
No, Judge, we looked at them. We're good with where we left off.
Okay. Right. So it's just 33.1, 34.1, and 35.1. Otherwise, not the entire document. And 36, 37, 38, there was no .1s on those, so they are not being moved. S40, we're moving in A and B. But that's the only areas. Okay, we had we were going to revisit S42 and 43. Ms. Wallace, where are we with those?
We just spoke to Mr. Murray. We are good with S42 being moved in, but not S43.
Okay. So you're not attempting to move in 43, correct?
That's correct, Judge.
All right. And you're good with that, Mr. Murray?
Yeah, I took another look at 42, and I think that the large bulk of it was testified to already, so we don't have an issue with that.
Okay, great. Thank you. S44 through S53, all in evidence. Next one is S61, A and B are in evidence. The next were the S60 through 65 that we reserved on. Did we come to an agreement on that?
Judge, the state's position is still that those should be moved in. I would note that we did mark, or we did look at and we put up the index on that, which is what Detective Niglorisi actually drew on at one point. And that index had the dates of 4/13, 9/13, 9/17, and then 11/5. So I understand, obviously, that's the state's position.
Okay. And the defense's position, go ahead. I know you have objected to it because you said it was confusing, the way that you have to read it. It was a little difficult. But was there anything else that you wanted to add to that?
Judge, if the court is inclined to allow it, then I would just ask that they be like page numbered, so that at least if they do get disorganized, there's some sort of mechanism to put them back in order. Perhaps they can just number them.
That's fair. That's fair. I'm going to allow them in, and I'm going to ask for them to have page numbers. I agree that the page numbers would be helpful. I do find them to be relevant under the circumstances they were testified to. And I do find that under the circumstances, the jurors should have them. But can we have Ms. Wallace have somebody do some page markings on these? I know it's going to be a lot to do tonight.
Yes, we could probably put them in binders too. We can even print the index. I don't know if that's something that'd probably be helpful, having the index on it as well.
Fine too. Just as long let the defense see that at some point.
Okay, and I was just gonna add, if they're gonna put it in binders, that makes sense, to do like a cover page with the date, to organize them by date.
Yeah, that's fine.
Again, our initial position is an objection, but that's.
Of course. Yep, your objection is definitely noted from before. It's noted again here today, but I'm going to allow it in. However, I do agree with you that page numbers are helpful. Okay. S66, A and B both in. S69 and 70 both in. Next is S74. All parts of S74, A, B, C, D, and D1 all in. S76, including clips A through D, all in evidence. S78 in evidence. S93 in evidence. S94 in evidence. S96, and I believe it's just B in evidence because the first 911 call was not something that was a hang up or something.
That's correct, Judge.
Okay. So it's just B. S99 in evidence. 101 and 102 in evidence. S155 through 166, all in evidence.
That's the context for the messages.
S168 through 177 in evidence. We reserved on 178, which was the padlock Pelican Storm case, 2050 with a knife flashlight. If you guys had the opportunity to discuss that again, has that been worked out or no?
I don't think it's been worked out, Judge. It's a locked case which was opened for the purposes of removing the gun and sending it for testing to the state police. We submit that. Obviously, there was a lot of weapons that we didn't utilize in front of this jury, but that is one of the handguns that was tested, and that was the way it was found.
Okay. All right. Ms. Mastellone, I know you objected to it, but I'll allow you to, if you want to object any further now, or if there's anything else you want to add.
Nothing to add, Judge, just objection.
Okay. I find under the circumstances that the jury, because the jury is not going to physically have these items, that it's more of the testimony anyway. However, I do find under these circumstances that not all items were sent to the state police lab. This one was. If the jurors for some reason had some reason to want to see it, it will be in evidence for them to be able to see. I don't know if they even will, but I do find that the probative value outweighs any prejudice to the defendant. Again, for the reasons that these items, as it relates to all of these guns that were located at 27 Tilton, they're not all going to be physically in evidence, so I have no issue with it. All right, S179, 180, 181 are in evidence. S183 through 196, all in evidence. S214 in evidence.
I'm getting a question from Mel Von Malters about whether jury deliberations would be tomorrow. The closings will be in the morning. I assume he'll give the charge and then give the case to the jury and not wait until what's tomorrow, wait until Thursday. But we can only hope.
Anything else you want to add to that?
Judge.
Ms. Mastellone, I know you objected to it before. I'm just giving you
The New Jersey judges are appointed, not elected.
Say anything else?
Judge, I'm just gonna other than the text messages, when we're dealing with the ballistics, since that was Mr. Murray's witness, I'll let him.
Yeah, there's baby judges school.
22, we don't have an objection.
Nick.
Okay. That's an evidence. All right. S230.
What was there on 225?
Federal courts have the Federal Judicial Center, and the new federal district judges go in for sessions. I taught criminal procedure to the new federal district judges at one point.
I have it crossed off that I was not allowing it in evidence, 225 or 226.
Okay.
The arguments can be made, but I said no to the actual items going in. 230, 231, A through E, and then 233 up to 242, all in evidence. 256, A and B in evidence. 261, 261.1.
Yeah, he's been in jail 7 years. It's kind of anticlimactic in a way.
263, and all of its subparts A through M, and there was a lot of point ones.
But you heard his daughter mention it when
evidence.
he was asked about not having her dad with her, and she said, "Hasn't been with me for years." Something like that was her comment.
270, 271, to include A, B, C, D, E, F, and then 271A1 and 271C1, all in evidence. 272 in evidence, 273 and 274 in evidence. 285
Thank you,
and
Lucy and
subparts
Zal.
A and B, and point 1 and
Lucy
point 2
and
in
Zaladua.
evidence. 299 through 338, all in evidence.
Nikki 704. That's true. There is a difference between
347
county
in
and state.
evidence. 375 in evidence. 391 in evidence. 392A, E, and H, all in evidence.
Maybe Judges School doesn't do as much as you think, Nikki 704, but they also have
405
continuing
in
education
evidence.
that they can do.
407 in evidence. 418 and 419 in evidence. 437 in evidence.
There is no death penalty in New Jersey,
467 in
Lucy
evidence.
and Zaladua.
474 in evidence. Then we said we were going to hold off on 476 through 480. I don't know if there was any more consideration as it relates to the DNA from the state. I know that the defense is going to be asking for certain items. I'm not saying I'm going to put them in. I'm just saying that they wanted to move certain items of their evidence from their experts. So I'm asking you what your intention is with these items.
Just trying to recall what they wanted to put in from their expert.
Mr. Murray, that was your witness as it relates to Dr. Reich.
Well, Judge, there was also the exhibits that were published during Daniel Reed's testimony. I think we didn't really get to those last week when we talked about.
Okay, which ones were you looking at there? So Mr. Decker will be able to argue, or Ms. Wallace, whomever.
That was Ms. Stallone's witness. On cross, she can correct me if I'm wrong, but I would imagine it was 140 through 143.
They were the,
S 140 to 143 or D?
D 140 to 143.
Okay.
just they were the, and the state, when we initially showed it to them, they didn't have an objection. There was nothing additional, I think, that we had, or from his poem.
One is the one you wrote on. I think that's 140 or 141, right?
Yes, 140 is Bodie's chart, likelihood ratio chart that I wrote on.
Yeah.
141 is the allele chart that's highlighted. And then we have the two deconvolution reports.
Belmont mockers, will the judge recite every evidence number chronologically? To whom? They're just going over one by one which are going to be submitted to the jury. He's not going to give the jury a list. He's just going to give them the box.
We were initially asking to be entered into evidence. I don't recall what the state was asking for. I think we wanted an opportunity to confer with them. We just haven't spoken about that yet.
Yes, Melissa Nevon,
I'm
interested.
just struggling with the idea that, obviously, we want the Bodie results in on that chart, but there's other results that are in reports. And then we just have certain documents, just because they're highlighted, doesn't make them any more evidential. I think it's
Well, there's writing on 140 that's testimonial. And then there was writing on 140.1, which Ms. Wallace got back up, used the same document, and then we pointed that out. And we made that a different exhibit. I have no problem with that timeline going in for both of you, both sides. I think it's fair. It's testimonial on the document. Swallows, I forget what you marked when you
started earlier.
You asked for it, and then we
On the DNA report switch or
on the Bodie report, and then there was the back of a notepad that was written on. If you guys remember, it was Miss Mastalone's notepad.
That was the timeline. That was through.
That's a different timeline?
Yes.
I'm sorry.
It's okay.
Well,
Mr. Murray's notepad.
And it started earlier. She had it earlier dates.
Like one exhibit, because we didn't preserve the notepad as an independent document.
Valid point.
Fortunately.
Right. Why, you don't want all your notes to be put in evidence?
I prefer not.
All right. All right, so your position is what as it relates to the Bodie chart?
The Bodie chart, I'm 100% comfortable with that going in.
All right, so that's
Obviously,
2.6. That's D140 going in.
and D4 is it 141? I have no issue with the allele chart table going in.
I don't see the value of the deconvolution report because there's areas of the report that was not testified to. However, I mean, the exhibits were shown on the screen. I think it's fair comment by both sides. Both sides use the deconvolution reports, less used by the state, more used by the defense. But I have no problem with those being discussed in detail if you want to discuss them. It's just that the entire report, and there's a lot of areas of the report that was not discussed, and I don't want them getting confused as to what each thing means or and trying to figure it out. So
I agree, Judge. I don't necessarily need the entire reporting, but perhaps just the portions that were published.
then you're gonna have to redact the front page because there's items on the front page that some were testified to, some were not, as the Gelvin Rubin and the fallout ratio or the burnout ratio. Some of the stuff wasn't even touched.
I mean, Judge, if we had a little bit more time to think about it, then, we could perhaps come up with a solution. I'm not sure in this moment. I mean, again, things that were published, I think the jury should have access to it. I mean, maybe we could agree that they don't have it back there in the jury room, but if they wanted to look at it, we could allow them to see portions if they had a request.
Can I have a D142, 143, please? Thank you. You were standing up, Mr. Decker. I don't know if you want to say something.
I guess, Judge, I'm just trying to figure out, I just don't want to confuse the jury on, like, they're not actually getting the DNA conclusions in some respects, like the state police, the actual expert report from the analyst, but then they're getting like deconvolution reports that are part of the analysis leading to a conclusion, but they're just not getting the conclusion. Just because an exhibit was shown or published, I think the way I look at it is if I would have shown Chris Clayton his report and said, let me publish this and have him underline his conclusion, I don't think it would make the report any more admissible just because he pointed that out. I think it would be kind of like a great way to backdoor every expert report. We're all certainly going to talk about the DNA conclusions in summation and ballistics and stuff like that. But if we're going with like the expert reports aren't coming in, I think that's kind of where we're at.
I hear you. Go ahead, Ms. Bassalone.
Again, Judge, I really haven't had time to think about it, but maybe if it just in the event that they ask for a readback, be made available to them. If it was something that they, if it was a specific area of testimony that they were interested in.
Yeah, I'm not going to allow the physical documents in because a lot of it was not testified to. Anybody can comment on it. If it becomes an issue, excuse me,
You can
if it becomes
re-comment.
an issue on a readback, we can
There you go.
discuss it at that point. But I'm not going to allow it in for now for the same reasons that I didn't allow in other reports from either side, just like I wouldn't allow Reich's report in. I wouldn't allow some of these deconvolution reports because there's so much information on here. I find that under 403, it would be confusing to the jury to fully understand all of it. And I would not want them to go back and trying to do become their own expert in DNA analysis. So I'm not going to allow 142 and 143. But again, if something comes up during a readback, then we can discuss it then.
Should I just ask one question?
Sure, sure.
We didn't get to, I understand the court's ruling on Dr. Reich's report. There was also the PowerPoint presentation.
Yeah, let's take them one at a time. I'll get to you. I didn't mean to jump ahead. I was just using that as an example that I throughout all of the state's exhibits, I didn't allow any investigation reports or any other person's reports. I was only drawing the same analysis, but I didn't get to that yet. I didn't know you were even trying to move it. So let's wait until we get there, if you don't mind. So can we go back to the state? So just with the record remains clear. Considering that the court is not allowing deconvolution reports, is there any request for 476, 477, 478, 479, and 480 for that example?
No, Judge, under the same ruling, I would suggest that would be consistent.
All right, so no to all of those.
Do you all want to stay and listen to the rest of
And
these?
again, the free game.
Because we're not seeing the evidence, the exhibits. It's pretty hard to get an idea of what they're talking about. But
I think the only other one.
let me know whether you want to stay and watch anyway.
Defendant and his daughter.
Go watch the Guthrie videos
501.
and come back at 5:30.
Is that being moved or is that not being moved? I don't recall.
No, Judge, I don't think that foundation was properly accepted by the court.
And anything that happened today and any of the exhibits that occurred, or do you want to wait to hear what the defense is going to request before you get into that? It was 502 through 505, I would assume, because the last one I had was 501.
Okay. I'm not seeing a lot of comments, but those that I'm seeing say it's fine to just cut it now and come back at 5:30. I don't know that I heard him. Is he starting at 8:30 tomorrow? I should know what he said to the jury, and I don't recall now.
504 and 505.
504 and 505 deal with the cell phone
Yes, that
and the
is,
extraction.
yes, that's correct. 504 is the first page of that. And then 505 is another page that was shown.
Okay. So my question to you is that the.
Does anybody recall what he said?
Again,
Is it 8:30 tomorrow that we're
how we
starting?
got to where we are
I
today.
didn't write it down.
So we don't need to go back
Sorry.
to that from this morning. But if it was an agreement not to put in the
Okay, 8:30
phone,
tomorrow.
the screenshot of the phone where it says it's red, how do I put in 504 and 505 after the testimony is already out there, but not the reports?
Yes, I didn't realize there was an agreement not to put I don't think I understood that, not to move in the screenshot.
Well, it wasn't, and I know we discussed it, and I believe what Ms. Massalone said, and I will not put words in her mouth, she can say whatever she remembers, is that it was my understanding that she was not intending on doing it. However, if something came up, she would let us know at sidebar that there was some questions that she wanted to ask, which she did not do. So with that being said, that is the reason why that I'm just wondering, considering we did not put any report in about this, if that's your plan. If you want to put it in, then I'll hear from the defense.
I mean, I think the state, I think the state would be seeking to move that in. There was testimony about the facts of the text message itself. This was shown to the witness. We marked it, we showed it to her. So I think for purposes of completeness, the state would be seeking to move these two documents in.
Okay. Hear from the defense as it relates to 504 and 505.
Judge, the court is correct. I mean, the defense was never intending to use the screenshot, but rather to simply elicit her testimony, which reflected her recollection of what occurred. I did not question her on the screenshot, and I sort of found out in live time that the prosecutors were going to question her about the group chat, which they did, and she wasn't able to. I guess the foundation was not really laid as far as the admissibility because she didn't recognize it. She's never seen it before. The prosecutor asked her, "Does this appear to be a group chat?" And she said,
That's why
no.
they want it in. It's the group chat business.
My position would be that either none of it comes in, which that was what I assumed was the agreement as well, or that in fairness they should all go in because again it goes to her credibility and completeness. She's not lying when she says that it is a text message between her and her aunt that says red. And we know that she's not lying because she testified to it under oath. We have a screenshot of it, and the prosecutors themselves saw the screenshot. They saw her phone earlier today where she showed it to them. If they want to suggest that it's a group chat as opposed to a single screenshot, if they want to show that that's what the extraction shows, then fine. But then we should also be able to show what this witness was looking at, her own phone and the screenshot. So I think as a matter of completeness, it should be nothing, which was originally what we assumed, and I didn't question her about it, or it should be all three items.
Male prosecutor has a headache.
Anything else?
No, Judge, I'll leave it in the court's discretion.
I think that the testimony was clear. I'm not going to allow the document in because I'm not allowing the screenshot in under these circumstances. But the testimony is out there. The document can be referred to as part of your summation as to to remind them of the testimony. I'm not sure if I actually agree with the defense that because she testified under oath that she was telling the truth.
Yeah, I agree with you,
I don't
Judge.
know if she is or she's not. All I know is what the extractions say. She saw extractions from the defense. She recognized it. She saw an extraction from the state. She doesn't recognize it. All I know is that I'm not going to allow them in, but I will allow the state to comment on those items 504 and 505. So they will not be in evidence. Now let's go to the D exhibits.
Judge, I do have a concern about, I don't know what the state's comments would be
Oh God, here she goes again.
as far as that exhibit, because, it would have to be consistent with the testimony. Otherwise, the state is essentially testifying. So I'm not sure.
Like she hasn't been. Oh God.
Again, I think that the defense and the state could meet and confer, and we could come to an agreement if we had a moment. But obviously it wouldn't be appropriate for the state to be testifying to things that weren't testified to by this witness in their closing. As to the witness's credibility, Judge, again, the state saw the phone, so I think that speaks for itself.
I didn't see the phone. Is that what you just said? I didn't see the phone. I have no idea what the phone shows and what it doesn't show, but it's not, I don't need to see it. It's the back and forth from you all. I've made my ruling as it relates to this. If the state and defense want to confer as to what they're going to say, they're experienced prosecutors. I told them what they can and they can't say. What it's within the testimony, and they know what she said and what she didn't say and how it was confronted and what the report, what questions were asked about the report. So I'm going to leave it at that.
I wish I knew why the group text was important.
Get in the middle of that because that's a different issue that I want to stay away from. So I'll leave it at that. All right, let's go to the defense exhibits. Mr. Murray, what I had, tell me if I'm wrong, your first exhibit that you moved in was D55.
That's right.
Okay. And then we had D64,
Yes.
D71 and D71.1.
Yes, those are published exhibits that we are moving.
Okay. 106.
106, yes.
Okay. 114.
Yes.
122.
Yes.
And then we're to what we discussed. Now, from your DNA, tell us which ones you're looking to move.
So I think there's an agreement on the 140 and 141.
Okay.
Those were the marked up exhibits.
Is that correct, Ms. Wallace?
That's correct.
Okay.
The court's ruled on 142 and 143.
Right.
Then we had D150, which was published, which was the PowerPoint from Dr. Wright. Now, obviously, we're not looking to get in his report, but I think similar to the testimony of Detective Bassender, where, you know, it's not the entirety of a record that's coming in, but a demonstrative chart that the jury is going to have available to them. You know, I kind of see the PowerPoint to an extent the same way as those charts, so we're planning to offer that as evidence.
And that was, tell me the number, because mine's, your exhibit list stops at 144 for me.
Oh, so that's D150.
D150. State's position.
I mean, I just think it's another report that he drafted. We're leaving out a lot of DNA conclusions in this case. They're not getting them other than what they heard from the witness stand and what they're going to hear from me and or, you know, defense counsel tomorrow. So I just think it's kind of a little selective in the sense that they get some results and not the others.
Can I see the PowerPoint? Do you have a physical copy of that?
Okay, Willow Armadillo wants to know how Mahjong is going. I don't know how many people are interested, but
We're under the Rule 1006 summary of voluminous documents. It's just to demonstrate the report.
in one word, I could say slowly. In more than one word, I could say I have a better overall understanding of what we're doing, but not a great understanding by any means. But I did learn how to use the Mahjong app, Mahjong for Friends or with friends. I had someone show me how to use the app.
Let's put it on the screen.
And the app is demonstrating to me how much I don't know about the game, because it keeps telling me I can't do what I want to do. So, but I'm going to practice. I'm going to use the app on the plane, because it's hard to do a lot of stuff on the plane, and unless they're really good movies, I will practice Mahjong on the plane when I'm on the plane.
Oh, close. All right. So this is this page one?
This is page 1.
I did buy myself a cup, though, and it had a lid so I could keep the coffee warm. But after I washed the cup in hot water, the lid no longer will fit in the cup. The cup has a kind of a metal.
Page 3.
rim, and I'm thinking maybe it expanded with the heat or contracted with the heat. So I'm going to have to discuss it with someone else who has the same cup to see if I'm doing something wrong with the cup now.
Sorry.
Page 6. Page 7. Page 8. Page 9.
Oh, good. Let them have those charts. They're impossible to read. But it does seem to me those shouldn't go in if the charts that the state had are not going in.
Page 11. Page 12. Page 13.
That's the state's chart.
Is this already in a clean copy?
It's already in a marked up copy, I believe, Judge.
Okay. This is 13?
This is 13.
Go ahead. Page 14. Page 15. Page 16. Page 17. Page 18.
It's 17 to 17.
Okay. Can you go back to page 5, I believe?
This is 5.
4. Let me just see. Three and 2. Okay. Okay. The court's position as it relates to this document, this PowerPoint that was used by the defense expert in this case, which argues that, or that the defense's expert indicated that
Said
while some of the results were reliable, it also talks about how there were certain areas that potentially of another person being involved in this, or another person's profile was at the scene. The court finds, as it relates to third-party guilt, it's going to allow only certain portions of this to be allowed to be used. I'm going to allow slide 2. Go to slide 10 so everyone sees it.
Can we see it, camera person?
10 will be allowed. 11, 12, which shows no unknown contributors out of fairness to the state. And then slide 13, where that shows an touched Bodie report as to relates to not only the people that were excluded at locations, included at certain locations, but it also allows for the state, as it relates to the reliable results that were testified to, that he has a document that is not that has not been touched or altered in any way. Mr. Decker, I understand from your perspective that how do we have the defense to have certain charts to be available when the state does not. It's the court's position, right, wrong, or indifferent, but the court's position is that the defense's theory in this case deals with the issue of Corey Caneiro. The court finds that there is, whether there is a rational basis or not, is not for the court to decide, but that it was testified to. I'm going to allow it for this limited purpose, but I will also give you the ability to address that any way that you need to in your summation.
Thanks, Judge.
So it's 2, 10, 11, 12, and 13. Yeah, that, Mr. Murray?
Yes, so that's what can,
That's
in evidence.
2, 10, 11, 12, 13 in evidence. The rest of the slides are out.
Can the additional slides be commented on?
Yes.
Or part of a PowerPoint for closing?
Well, they're not in evidence.
Right.
So they can be discussed, but they're not in evidence. So they shouldn't be on the screen. But these, you have carte blanche to do whatever you want with.
Okay.
Can't use it as a demonstrative in closing, really?
Oh, not this.
Just for the two.
This one?
Yes. 10, 11, 12, 13.
Can you just go back for a second?
Sure. This is it.
Now, this is his witness, but she's over there telling him what she'd like him to do.
Judge, can this one be admitted, which shows the alleles that are unique?
I've already indicated my position as it relates to the items. I know you asked to put them all in. I'm not putting them all in. I find them to be cumulative. The one provides the coloring that shows the differences and also the shared alleles for each one. And so I'm allowing one of those documents, and that's the one that I'm allowing. Was Mr. Murray, any other items between 145, I guess, and 150 or 151 beyond that I'm unaware of that you're attempting to move? And then I need an updated exhibit list from you by tomorrow morning, please.
So other than that, the slideshow, I don't think I can ask Ms. Massimo, I don't think we're moving any of the things.
Just the photos.
Just the photos, yeah. No documentary exhibits, so that would be it. Only the 150.
Okay. All right. So now we can go to the defense photos. Have they been reviewed and agreed upon, or do we have certain ones that I need to address?
I don't think there's any objection to any of the objections.
We should, for the record, though, Mr. Murray, we have to put them on the record as to what numbers that they are.
Do that now.
Yeah, whenever you're ready.
The one, I don't need to do the point exhibits, do I? I mean, I can.
No, if you're saying, is the agreement to include the point ones in what you're saying?
I looked at the .1 exhibits a little while ago. There was one that was duplicative, which I told Ms. Mastalone, I believe she took it out, but otherwise they're fine.
Otherwise, you're good.
Yes.
So you don't, Mr. Murray, you don't have to say slide 1, 2, 3. If it's slide 1 through 30 that are in, then you can just say that. But you tell me. I don't know what you're going to say. So go ahead.
What does she want him to do now? Look at the prosecutor looking at her. It's really amusing.
Okay, so I think what we have as a map, and the point ones are, I guess we'll do the point ones next, but
Okay.
this is, so we have, these are all D1 exhibits, so 1, then 6, 7, 9 through 12, 15 through 17, 21, 27 through 31, 34 through 38, 41, 43, 44 through 66. I missed, but we need to, there's no 1-50, but other than that, 44 through 66, but there's no
50.
There's no 50.
Okay.
71 through 75. 79 through 97.
I'm sorry, I'm just trying to keep up. I want to make sure we have everything. Did you say, where did you end up with the 60? 66?
66, yes.
Okay, and then we are at 71?
72, 73, 75,
Okay,
79.
yes.
And then it's going to go
You had
80.
74 too, right?
Yeah, 74.
71 through 75, yeah, to include 74.
And then 79 is going to go all the way from 79 through 97. We have 100 and 101. We've got 116 through 127.
116 to 127?
Yeah.
Okay.
Thank you.
Yeah.
122.
There's no 122. Oh, I'm sorry, there is no 122 on our list.
No 122. Okay, no problem.
127 is our, okay. And then after 127, we're going to go to 134, 136, 137, 141. Then we're going to go to 145 through 152. 166 through 169. 172, 73, and 74. Then jumping to 200 to 206. 208, 210, 211, 214, 216, 224, 226 through 231, 235, 36, and 37, 240 through 245, 251, 252, 254, 255, 256. Oh, this is okay. So then 257 through 262, 264 through 2. I believe it's 264 through 287.
281, 82.
No, I'm sorry, I don't. I have 80 to 83. So, except for 81 and 82.
Okay.
291 through 293. We're going to 300, 301, 303, 304, 307 through 309, 311, 317, 317A, 318, 318A, 320, 321, 328 through 332, 400 through 403, 'and then we're at to end. We're going to have 420 through 430. Yeah. There is one issue is that I think 423 was that screenshot of my notepad. So I don't know if there is an actual 423 or if it's just a 423.1.
Well, if you didn't mark the back of your notepad, it would just be the 1.1.
I think it would just be the 1. Okay, so I'm going to take that out.
423.1.
423.1.
You want to,
I'm not objecting, I just want to.
no, I was talking about,
Sorry.
I agree, Ms. Wallace.
It's one. All of a sudden, it feels like.
You mind hitting the down arrow on that?
Doesn't work.
Just hit it anyway, just for fun. I'll try to turn it down a little bit for tomorrow. I agree.
It can happen suddenly.
I'll do yours. Thank you, though. I'm pretty sure Damie's listening in the back. Damie, if you can ask Buildings and Grounds to come tomorrow and drop it 2 or 3 degrees, I'd appreciate it. maybe 10. Any, you want to go through the point ones? I'm assuming you were done with the regulars.
I think that's it for regular funds.
Okay. So just give us some point one and we're done. And then we'll move on to the charge.
Imagine all those exhibits that the jury is going to have. Do you think they're going to look at all of them? I would say no way, Jose.
It is, 1-1.1A, and then 100.2, 100.3, 101.2, 101.3, 101. There was actually, it looks like 101.2. Twice, so it's 101.2A or 101.4, whatever the court prefers, we can amend it.
Yeah, we'll amend it to 101.4, please.
And then 300.1, 301.1, 301.3, 301.4, 309.1, 317.1, 317.3, 317.4, 317.5, 301.2, 317.2, 307.1, 423.1,
423.1. Am I right? 423.1?
yes, Judge.
All right. And again, no objection from the state, correct? All right. We've gone over the charge. Everyone has the final draft. It's been marked as C9. All the other drafts have been marked and will be preserved.
That's just in case there's a challenge to an error in which instruction went to the jury or which exhibit went to the jury. You have to keep the history of everything they've done.
I know I've gone over it before. I'm just going to go over it. Stop me if anybody has any issues with any part of it. I want to go over it one last time. We start with the general information, then the nature of the indictment, presumption of innocence, burden of proof, reasonable doubt, function of the court, judge's questioning. I've included in the request about sidebar conferences. I added that into the area to the function of the court, the first two paragraphs. I'm not sure all of it was necessary. However, in abundance of caution, I put it in. Judge's questioning, function of the jury, direct and circumstantial evidence. We forgot to read the stipulation to the jurors, so that we need to do that. So tomorrow morning, just a reminder, and I need that stipulation. So if you guys want to write it up right now, so that thank you, we'll add that in to the stipulation part. Credibility of witnesses, identification. And right after identification, so I'm on page 9 of 55. Ready there? Okay, good. My thought would be after identification, that's where I would put defendant's election not to testify before expert testimony. If you want it in a different spot, I can do that. I can wait until later after the statement of the defendant or narration testimony or defendant's recorded phone conversations. That's up to you. But I thought after the identification, Mr. Caneiro is denying his guilt, and also denying that it was him, that the state has to prove beyond a reasonable doubt. I thought that was a safe place to put his election not to testify. Any objection to that? Or if you want it in a different spot, just tell me where you want it, and that's where I'll put it.
Judge, we were thinking that perhaps it would be best to put immediately before you begin the 2C portion of the.
You want it there?
Yes.
Fine, that's where it goes then. So right after third-party guilt is what you're saying?
Right.
Okay. That's where I'll put defendant's election not to testify.
Or criminal. Yes. Right. You're right. That's right.
Okay. Okay. So we'll add that in. And we'll obviously clean up the charge to make sure it just says his in the spots that it should just say that, and to take out the footnote at the bottom on there. All right. So then we have identification, expert testimony. We have all of the experts on there. Prosecutors, can somebody remind me how to say Christopher somebody's?
It's on Ms. Wallace. Has this been Kovic?
Wait,
Koviak?
Simkoviak.
Simkoviak?
Is it?
Okay. All right. And Nazizan?
Yes.
Nazizan. All right. The rest of them. Was that our Cardenas?
Cardenas.
Cardenas. Okay. All right. Then there will be the statement of the defendant. Narration of video narration testimony. Defendant's recorded phone conversations. Limiting instruction relates to the firearms. Witness pretrial prep. Third-party guilt. And defendant's election not to testify. Nobody has any issues with any of those areas, correct?
Not so far, Judge.
Okay. Mr. Murray and Ms. Vanessa.
That's fine, Judge.
Okay. Then we go into the criminal code. We discussed, and I had indicated that the lesser included was the arson. I want to be clear that in this case, there's no lesser included to the murder. In this case, I've spoken to defense counsel in the past, and there was a discussion with Mr. Caneiro that there was no lesser included that were being requested. Is that correct?
That's correct, Judge.
So
Yeah.
it's
For the
murder
record
one or
purposes,
nothing?
I would say there's nothing rationally based within this record to support anything other than whomever committed these offenses against the four victims. It's not an aggravated manslaughter. It's not a manslaughter. It would only fit the requirements of a murder. I don't find any evidence, any
So it could be
scintilla of
murder too.
evidence that there was any reckless behavior here. It was intentional, deliberate. So in that case, I wouldn't do it even over the defendant's objection. I agree with the defendant and defense that it does not exist. So after I read the murder charge, then I will explain murder by your own conduct, and then the verdict sheet instructions, as everyone will recall. I will give out the verdict sheet at that point. We'll need 16 verdict sheets for tomorrow. My law clerks who are seated to my left, they will give out, they'll have 2 packages of 8. They'll give one to the first row, one to the second row, and they can take one, pass it down. I'll then go over the instruction as it relates to each one, as it relates to the murder by your own conduct, and also the subsections afterwards of A, B, C, and D. For Keith, B, C, and D for Keith. And then for Jesse and Sophia, there's also the additional question as it relates to age for both Jesse and Sophia. I'll ask them about that. Then I'll take the verdict sheets back so that they don't sit there and stare at it. And then we'll go to felony murder, count 5 and 6. Then aggravated arson in counts 7 and 8. After the aggravated arsons for counts 7 and 8, I'll then read the lesser included offense of arson, which again is the underlying charge for the felony murder. Then it is possession of a firearm for unlawful purpose, which is count 9. There's no count 10 now, so we'll go right to count 11. The verdict sheet that I have in front of me still includes a count 10, so count 10 needs to be taken out. Oh, no, I may have an old one sitting up here. So, yeah, so that shouldn't be in there. Oh, yeah. All right, this is an extra one. A lot of stuff going on up here.
Closings are not administrative, Linda 460. They have to be done in open court because they're made to the jury.
Yep. Then we get into the knife, which is count 11. And unlawful possession of the knife in count 12. Theft in count 13. As it was discussed with counsel, defense counsel had asked for the lesser included as it relates to the amount of theft that was taken. It's clear, though, in the charge on page 45, starting at the top, where it indicates that to find the defendant guilty of the offense, you must indicate whether you find the amount of money or value of the property involved. And it gives 4 different numbers: 75,000 or more, 5,000 but less than 75,000, between 200 and 500, and then less than 200. So they'll answer that question based upon whatever answer they give. That would be the degree of crime, if at all, if they find him guilty of anything as it relates to the theft. Then there's count 14, misapplication of entrusted property. Then hindering apprehension, counts 15 and 16. One deals with hindering the apprehension for the underlying crime of murder, and then hindering the apprehension of theft or the misapplication of entrusted property. Let's count 15 and 16. Then we get into, I give an instruction about deliberations, how it must be a unanimous verdict. I then give the verdict sheet back out, and we'll go over each one of the questions, and I'll remind them of that. I'll explain to them how they have any questions. If they have any questions, how they go about asking them. After that is done, I'll ask for a sidebar for the attorneys to see if I've missed anything. I'll then have, I'm going to ask for, Anna, that you'll need to look at whichever one applies. We'll have to swear in my sheriff's officer who will be at the door for deliberations. I'm also going to swear in a sheriff's officer who will be at the back door so that I can say for the record that this entire room is secure. I will swear them in, and then at that point in time, I will pick my 4 alternates. We need to get the wooden box, and if you can put the 16 numbers into that, we can take care of that. I will then do that. 12 will go in the box, and they'll start their deliberations. Please, at the end of summations, I'll give you guys a break. But when summations are over, I'd like to have all the evidence collected. I want to put the evidence into the jury room so that it'll be seated there waiting for them. If I don't think that we're going to finish tomorrow, where I would finish my charge, then we'll keep it out, and then we'll give it to them the next morning. Before deliberating, the 4 alternates will be brought back downstairs to 148. I may end up moving them because it's going to be difficult every time if we have a question or whatever it is. I got to bring them back upstairs. It's going to take a decent amount of time, so I may try to move them closer someplace. I got to figure that out. But as of right now, that's what they'll be in 148. Anybody have any objections, concerns, edits, issues that we need to discuss?
The state doesn't, Judge.
Okay. The defense?
Not at this time, Judge.
Okay. So with that being said, we will take the watermark off of the final charge. We will also mark, we will have to have marked for tomorrow 12 copies for all of the jurors so that they will be able to have them. I'll ask for us to make all 12 of them. We'll also have to turn over a copy to each one of the attorneys. So if we can make at least 16 of them copies of it, that's what we're going to need. Verdict sheet will need 20 copies of the verdict sheet. So everyone has one they can look at. Make sure with 21 to include Mr. Caneiro so he has his copy of the verdict sheet.
I don't see any questions. Nope, I don't. One thing I would say is the lesser includeds. I've explained lesser includeds before. The highest crime, the greater, would be A, B, C, D. The lesser included would be A, B, C, and even lesser included would be A, B. You can't.
Anything anyone needs to discuss before we conclude for today and we start tomorrow morning?
Yeah, Judge,
You
we
can't-
have a very detailed stipulation on a fancy piece of paper here for the court. I just, Ms. Wallace, looked at it. Showed it to Mr. Murray and Ms. Pastalone. I believe everyone's in agreement.
It says for the stipulation that would be added to under the stipulation section of the jury charge, it reads, Jesse Caneiro had an iPad. The parties agree that Jesse Caneiro's iPad was never seized or searched by police. Is that the agreement?
Yes, sir.
Is that the agreement, the defense?
Yes.
Okay. Do you want me to read that before we start summations, or do you want me to just do it as part of the charge?
I would think part of the charge at this point would be sufficient.
It's fine.
Okay, we'll read it as part of the charge. If somebody, out of fairness, if somebody comments about that in their summation, I will not have a problem with that because I will address it within the actual formal charge. Let everyone know that. All right. Anything else that we need to discuss?
Can we just have one
Do we
moment?
have a minute to confirm with the state?
Sure.
Okay, so you cannot commit the greater crime A, B, C, D without also having committed the crime of A, B, C and the crime of A, B. Impossible.
Oh, nice.
So theoretically, you've committed 3 crimes when you commit murder 1, but you only have 1 victim, so you can't be convicted 3 times when there's 1 victim. To say there are no lesser included means the only thing that's charged is the A, B, C, D, and nothing else. So you either are convicted of the A, B, C, D crime, acquitted of the A, B, C crime, or there's a hung jury. If the lesser included are charged, if the jury decides to acquit on the crime of A, B, C, D, it then can move to the crime of A, B, C, because the reason it didn't convict of A, B, C, D may be that they didn't think element D was there. What the judge was talking about is you only charge lesser included if there's a basis to believe that a jury could acquit of the A, B, C, D charge and that there's a basis for saying the A, B, C charge is still on the table. And what he was saying is for murder, it's the intent to kill. There's no evidence in the record that it was reckless, which would be manslaughter, that it was done in heat of passion, which would be manslaughter, that it was done negligently, there might be a negligent homicide. So there's no basis on which to charge those lessers because there's no way that a reasonable jury could find the element of recklessness. It's either intent to kill or it's not murder, and it can't be manslaughter. So anyway, that's what I wanted to just say and clear up. I will see you all at 5:30. It looks like we're ending. Tomorrow will be closings and instructions to the jury, and it sounds as though he thinks it may not even get to the jury tomorrow, which I don't understand. But what can I do? He's the judge. Ciao a tutti. So long, all profers. Hit the like button. Hit subscribe and hit, if you can, the whatever the other thing is, hype. So long.